The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, thank you. We'll begin with the first case, Claudio De Simone versus VSL Pharmaceuticals, and Mr. Brennan, we'll hear from you first.
Thank you, Your Honor. Robert Brennan, on behalf of Appellant Alpha Sigma USA, Inc. This is the latest skirmish in a long-running battle relating to two competing probiotic products, VSL number 3, owned by VSL Pharmaceuticals, Inc. and distributed in the U.S. by Alpha Sigma, and Visbiome, owned and distributed by Exegete Pharma, LLC. We're here today on Alpha Sigma and VSL's appeal of the district court's order finding them in civil contempt of a permanent injunction that was issued following a jury verdict finding Alpha Sigma having committed false advertising in violation of the Federal Lanham Act. Now, there's 4 elements that must be proven by clear and convincing evidence in order to find
Mr. Brennan, Mr. Brennan, good morning. Judge Diaz,
morning,
sorry
Judge.
to interrupt, and I'm going to let you get to your argument here, but I do have a procedural question related to the supplemental briefing that the panel requested on the status of the attorney fee request. Can you tell me or tell the panel exactly what the district court is doing or not doing with respect to the fee award?
The district court it has pending before it a motion for award of fees and an opposition, which it is holding, presumably pending an outcome on the appeal of the merits of the contempt ruling.
Has the district court said that, or is that your supposition that it's waiting to hear what we have to say about this?
That is my supposition. There's not been anything issued directly to that effect.
Okay. The reason, I mean, it just seems inefficient from my perspective to hear this appeal and then maybe that you all may come to some sort of an agreement on the fee issue. It doesn't seem like it given the history of this case, but we may well see it again. And it seems to me, well, there's a question. I think there's an open question, although I know you take a different view of whether or not this appeal is actually final, given that the fee award is still left to be decided. But at a minimum, it just seems to not be the most efficient way to do things.
Well, Your Honor, we think on the basis of the authorities that both sides filed in their supplemental memorandum that it clearly is an appealable order. And as Your Honor knows, one of the issues I'm going to argue here momentarily is that in this circuit, at least, fees cannot be awarded in the absence of a finding of a willful contempt. And there was no such finding in this case, and that is an error of law that the district court committed. And if the court agrees with us on that, then there will not that will moot the pending motion for an award of fees. So in that sense, it would be the most efficient for us to proceed right now.
All right.
Let me ask you another fundamental question. If I understand, the injunction was entered against Alpha Sigma and Liadiant. Yet the court found that VSL, VSL violated the injunction, but it was never named as one of the persons enjoined. What's your response to that?
I think that's better left to to VSL's counsel to respond to, Your Honor, Mr. Broughton, who's prepared to argue after my argument is over.
Well, this is pretty fundamental, and I looked at all the briefs, and I was disappointed that nobody in the briefs explained to me. Everybody noted that the injunction was entered against Alpha Sigma and Liadiant, and yet we have VSL, who was deliberately left out of the injunction order. Not only that, no counsel seemed to link conduct to any particular defendant. I mean, everybody used this collective term, parties, VSL parties, but yet we have individual corporations that are being held in contempt and the ones being held in contempt don't match the ones who were being enjoined. I just like some explanation for that. And
Sure.
I'm not sure passing it off ought to be the right answer.
So I'll address it then, Your Honor. I think, again, and I have to defer to my co-counsel who represents VSL, but my understanding is VSL would certainly not, even though it's not named in the injunction, would not take the position that it could go out and, for example, issue promotional advertisements tomorrow or today.
Well, that's not the issue. That's not the issue. The issue here is contempt for failing to obey an injunction. And the injunction on its face, and everybody recites in its facts pretty clearly that the injunction was against Alpha Sigma and Liadient. And VSL was a party, but was not named as part of the persons enjoined. And that's for some good reasons, which I don't need to go into, but and nobody, at least to my knowledge, broke down the corporate veil or suggested that the corporations are responsible for each other's conduct.
They clearly are not. And one of the arguments that we made in our briefing and that I would make here is that the court has seemingly said that it's ordering the VSL parties to pay attorneys' fees, and it found the VSL parties to be in contempt. And we do push back on that. They are independent entities. My client is not responsible for the independent actions of the parent company of VSL, and doesn't think that it should, to the extent that.
No, that's a later question I do want to ask also. I mean, Actiel was the person that issued the press release, and they quoted an official of VSL, but that's hearsay issued by Actiel, which is apparent, and I didn't see anybody suggesting that we should attribute the parent's conduct to the subsidiary. Maybe we should, but I didn't see it in the district court or in the briefs. I found the briefs on both sides. I need to comment on this. I found them very unhelpful in terms of trying to figure out who did what at what time. And how do we assess whether there was a violation that was justified and the nature of the conduct and so forth. It's everybody just seems to spray conduct to the VSL parties. And that's a handy tool to cover instead of saying who did what and then assessing each party. Anyway, that's my problem. And all of you, I'm going to ask you the same thing. So you can continue with the argument, but it seems to me we ought to be focusing on, number one, who was enjoined, what were they enjoined from doing, and did they violate the injunction? And the way the briefs are written, it would take quite an effort to sort it all out.
Well, Your Honor, let me proceed to tell you why Alpha Sigma at least shouldn't be held in contempt with respect to the actions that were attributed to it. And the first of those was the fact that YouTube video remained posted online. The grounds for a motion, as we know, are required to be stated in the memo in support of the motion. And the YouTube video issue was not raised until the first time in in Exige's reply memo, with no explanation for the delay. And thus that grounds we submit were not properly before the district court on this motion, and therefore it was error of law for the court to even consider those YouTube videos.
Let me ask you, what is the standard? I haven't understood the standard very well either. An injunction is issued enjoining parties from doing specific conduct. If a party violates the injunction accidentally, is that party in contempt? Or if the party violates the injunction recklessly, is that party in contempt? Or if the party does it deliberately, is there a standard that's required to find somebody in contempt of an injunction?
There is. There's 4 factors. There needs to be a valid decree. It needs to be in favor of the movement, and that needs to be violated. Excuse me. There has to be, the alleged contemner by its conduct has to violate the terms of the decree with at least constructive knowledge of that violation. And that cannot be found if there's fair ground for doubt as to the wrongfulness of the conduct of the question.
Well, that just
willfulness itself, willfulness is not a requirement.
That just attributes the conduct, which is pretty straightforward. My question is, what type of conduct is necessary? Is there any kind of a mens rea necessary to violate an injunction, not to violate the injunction, to receive a contempt citation for violating an injunction?
Not in a finding for civil contempt. There is not.
It can be done accidentally?
As long as it's in an accident that you have at least constructive knowledge of the fact that it's violating a court order.
Yeah, but all right.
If it's purely neglectful and if it violates the order and you've got constructive knowledge of it, then you can be held in civil contempt. Willfulness is not a requirement. Willfulness is a requirement if, as an additional remedy, in addition to making an award based upon any harm that's proven by clear and convincing evidence, if you want to also award attorney's fees incurred in connection with bringing the motion for contempt, then it has to be willful. But I can see I've already am now.
Can I ask you about the, you were talking about the YouTube video and you're concerned that it was raised in the SIR reply, and I get that. On the other hand, the statement that was of concern to the district court in that YouTube video was essentially the same kind of allegedly contemptuous statement that the VSL number 3 was clinically proven, which is essentially the same statement that, as I understand it, appeared in the Facebook comment. That's the first point. And second, I get the point that this was raised in a reply, but I think the district court took 10 months to actually enter an order in this case. And obviously you must have read the reply and you made no effort to file a motion to alert the court to this concern or file a SIR reply. So under those circumstances, why should we overturn the district court's ruling on that point?
I think that to addressing your second question, I think that to suggest that it's the onus shifts to the party that's we filed an opposition. We responded to the grounds that they made in their motion. They improperly raised additional grounds that aren't new. They're at least 2.5 years to 8 years old in their reply.
Yeah, but you're before the district court. You've tried cases. This is fluid. I mean, you come back and you're surprised by a reply and you say, Judge, I want to file a SIR reply and I want to file a supplemental memo on this issue, or you just raise it. District judges are taking that into account, and the court could have enforced it if he thought you were surprised. But that's not something that we address, because the court did address it. The court addressed it and chose to address it. And the only argument you could make is you had no opportunity to address the point. But as Judge Diaz said, that's not the case at all. We just have, your argument is very formulistic that the district court is bound to accept an opening brief, a reply brief, and an answer brief and a reply. And that's not so. I mean, I tried cases in the district court. We had SIR replies and SIR replies and people objecting to this and answering each other. And the court has to take charge if it wants to. But in this case, the court addressed it. And you never raised a point about it.
I think that it shifts the onus. I recognize that district court litigation.
Isn't this something you have to present to the district court? The question is, did the district court treat you unfairly? And you had the full opportunity to address it. The fact that district court didn't adhere to a 3-memo process, it doesn't raise any rights that you have on appeal, does it?
I disagree. I think the district court did treat us unfairly. We're entitled to, we're here on a
did you try to reply?
Court order.
Did you try to address it? Did you try to address it? With a letter, with a motion, with anything? A motion to file a SIR reply? Did you do that?
We did not. But we're entitled to rely on the fact that the court is going to abide by its own rules. And if the rule says Judge Quattlebaum?
Yeah, thank you, sir. And I didn't mean to cut you off, but I think we understand your position on that. But my question relates to the Facebook, the violations of the alleged Facebook, and I've read the briefs, but my question is pretty simple. Is there any question that your client was responsible for the information in the Facebook messages? Are you contesting whether that is an Alpha Sigma issue as opposed to someone else?
We're not contesting that, Your Honor. We don't. It's not directed by Alpha Sigma, but Alpha Sigma's had agents that are in a vendor that runs the Facebook.
And I didn't mean to. And I'm not minimizing your other issues. I just want to make sure I understand that particular factual issue. So thank you very much.
So there's been a lot of questions. I'm well beyond even what I had left for rebuttal, but I'd like to address a few brief points about no finding of harm with respect to the YouTube videos, the healthcare provider letter, and the Facebook postings.
Why don't you reserve that for your rebuttal? You have some rebuttal, don't you?
I've got 2 minutes.
2 minutes, okay. Why don't we hear from Mr. Broughton?
Thank you, Your Honor. Turner Broughton here on behalf of VSL Pharmaceuticals. And Your Honor, I want to jump in and address 2 questions that I believe that you asked. The first was about the injunction and the parties. And at the trial of this action, Your Honor, it was Leading and Alpha Sigma who were found to have engaged in false advertising. And so to the extent that the order below dealt with false advertising, it did so against only those parties and not VSL Pharmaceuticals, because it was not itself found to have engaged in false advertising at the trial court level. And so I believe that's why the trial court order addresses those 2 parties as the parties and issued the injunction against those 2 parties as to false advertising, because those are the 2 parties that had. As to the standard question,
Well, let me just follow up on that. If that's so, where does the judge get the right to hold VSL in contempt when it never gave VSL notice that it was enjoined?
Your Honor, and there are statements that were made at the conference in which VSL's counsel acknowledged that it would be, I agree with Your Honor, that in terms of the order itself, the order does not put VSL on notice, although there is a statement, which I'm sure Mr. Schulman will address, from counsel at the trial level, who acknowledged that VSL should not, as Mr. Brennan said, be able to go out and engage in contumacious or false advertising.
Yeah, but that's not the issue before us.
Correct.
I mean, you can sue them and you can get a remedy. This case is narrowly with respect to the violation of a court order, of an injunction. And
Correct.
VSL was not named in that order.
That's correct, Your Honor. That is absolutely correct. And so it is not a party to that order. I would also, the second question Your Honor asked was about the standard. And the standard, which is found in Taggart v. Lorenzen, is objectively unreasonable. So it's an objective standard. But if you look at the Taggart case from the United States Supreme Court, it really talks about whether the contumacious conduct or the statement at issue or statements that are contemptuous were objectively unreasonable. And so that's the standard by which each of these statements should be judged, which is, was the contemnor objectively unreasonable in the statements or other contumacious conduct in which they engaged?
Does that include any kind of mens rea? In other words, does the person have to know that he was, when he conducted himself, that he was violating the injunction? Or does he have to, in other words, is there any level of, you use the word contumacious. That is, if that's the standard, contumacious is a level of intent.
So, Your Honor, I believe in the Taggart case, again, which is the best case on this, the court essentially acknowledged that subjective intent is not necessarily determinative, that it can be factored into a finding of contempt, but that ultimately a party's subjective intent is not determinative of that finding. So turning to
Mr.
Yes.
Broughton, could I ask maybe a just orientation type question? With respect to the various categories of conduct that are addressed by the district court. Which ones is VSL factually? I'm not. Did VSL actually do? Not whether they're. I know the press release, I think, is what I gathered from the briefs. Is there was can you address whether, and I know your colleague in opposition may have views on this, but from VSL's perspective, which of the conduct besides the press release is it responsible for?
None, Your Honor. It's the press release.
Okay. All right. Thank you.
Yes, Your Honor. And so, and I see that I've got about a minute left, so I want to focus. There really were three questions, and Judge Niemeyer, you pointed out the point that VSL itself is not bound by the express terms of the injunction. The trial court itself as well, there really were three questions. In what context was the offending word published? What is the standard by which the offending word, VSL's use of generic, judged? And was VSL's belief that its press release was in compliance with the court's order objectively unreasonable? And it's important to note at Joint Appendix 690, the trial court noted the following, quote, Guarna's statement, who was Actial, the parent company of VSL Pharmaceuticals CEO, in describing litigation in Italy, noted Guarna's statement was limited to a single occasion in a press release not focused on establishing equivalence between VSL-3 and the DeSimone formulation. And so VSL Pharmaceuticals was found in contempt as a result of a statement by Actial in which the trial court acknowledged that the press release was not focused on establishing equivalence, and that was the very purpose of the injunction itself, which was to prohibit. How
did the court impute Actial's press release to VSL?
And Judge Niemeyer, I'm beyond time. May I continue?
Yes, please.
Because Mr. Guarna is both the CEO of VSL Pharmaceuticals, which is the American company, as well as of Actial Pharmaceutico, which is an Italian company. And so
he was acting on behalf of Actial, though, when he issued the press release, right?
Correct, Your Honor, because this concerned a verdict in Italy, and it related to Actial's a Roman court finding that Actial was the rightful owner of 8 strains that Claudio DeSimone had improperly transferred through Luigi Mento to himself. And I see I'm out of time at this point.
Okay, thank you. We'll hear from Mr. Schulman now.
Good morning to the court. Jeremy Schulman on behalf of the appellees, Claudio DeSimone and Exergy Pharma. Let me start by addressing Judge Niemeyer's question. VSL's counsel in the court below expressly acknowledged that the injunction, that they were bound by the injunction. That's what their counsel acknowledged. And it flows from Rule 65, which states that the injunction extends to the parties named and also those acting in active concert or participation with those parties. And so the court was, and I think the court was incorporating in its contempt finding its prior determinations, which included determination about the role that VSL and Alpha Sigma play with one another in jointly marketing the product. So there was extensive evidence that came out through the course of the case at trial and elsewhere that while Alpha Sigma may have primary responsibility for marketing, VSL retained under their license arrangement a role in marketing as well, in helping to develop the scientific substantiation.
But VSL was a party to the case, and the court chose not to enjoin VSL.
Because
that appeared to be deliberate on the court's part.
I think it was deliberate, Your Honor, because our claim for false advertising was asserted only against Alpha Sigma and Leadiant because they were the ones who were primarily engaged in the marketing that we were contesting at trial. And so the injunction that we sought was targeted against those key marketing agents. However, because VSL...
Do you understand that this contempt is being held against Leadiant also?
No, Leadiant was not held in contempt. We did not seek contempt against Leadient because.
Well, isn't that telling if the court issues an injunction against Alpha Sigma and Leadient and yet groups them together as the VSL parties, it excludes Leadient possibly because there wasn't any conduct attributed to Leadient.
I don't believe Leadient was included in the order, Your Honor. I think that was.
Well, I know it was not in the contempt order, but it was in the injunction.
Correct. Because Leadient was initially for about a month or so falsely advertising the product. Then they sold their rights to Alpha Sigma, and Alpha Sigma took over and continued that false advertising. So that's the evidence. Yes.
Mr. Schulman, if I could just follow up on what I think I understand the basis for seeking contempt relief against VCL. It sounds like at the hearing on this, VSL says, we acknowledge we would be bound by that. Correct. And I can kind of imagine that it would be a, kind of tough argument to go in and say a affiliated company, is somehow scot-free from violating an order. I get that, but is that the same and what's the authority, I guess, for equating that, which seems might be arguably a practical sort of thing. We'd look silly if we said we could do something but is that the same as saying they're subject to a contempt order that did not apply, or to an injunctive order that did not apply to them? So you see, I'm trying to say that I get, are those one and the same?
Well, they are, Judge Quattlebaum, because the injunction did apply to VSL. I'm reading directly from Federal Rule 65D, which it says persons bound. An injunctive order binds only the following who receive actual notice of it by personal service or otherwise: the parties, A, the parties; B, the parties' officers, agents, etc.; C, other persons who are in active concert or participation with the others. So,
but there's two problems with that. One is VSL was a party before the court, and so the injunction doesn't have to rely on the other. It's matter of fact, the indications would be VSL was excluded because VSL was a party and the court chose not to enjoin it. That's number one. And then number two, the court never explained that it was holding VSL liable based on that aspect of Rule 65, I don't think.
Well, it didn't need to, because VSL's counsel was readily admitting that they're bound. So it wasn't a contested issue.
So we have an order of an injunction that was not issued deliberately against VSL. Counsel makes this statement, which is ambiguous, but it makes a statement. And all of a sudden, we now have an injunction against VSL without a formal order. And then we have a contempt order saying it violated that order.
Before even the motion for contempt was permitted to be made, we had a pre-motion conference where the court was trying to assess these very questions, Your Honor. And we would have had
that's even more indicative. In other words, if you brought it to the court's attention, the court still didn't hold VSL to the injunction, and then still, and of course, there's no injunction, there's no formal order against VSL, and the question is whether counsel stands up and said, I'm willing to be held in contempt. They didn't say that. I'm a little surprised that it wasn't raised, but
what I'm saying is
it was raised indirectly. But
what I'm suggesting, Your Honor, is that this question of whether or not VSL was acting in active concert or participation did not need to be litigated because VSL's counsel readily acknowledged that they were bound. There wasn't any question to litigate as to whether or not the injunction would extend to them. They were acknowledging that it did. They were challenging our contempt motion on different grounds. They were challenging it by saying there was no contempt in Mr. Guarna's press release. So, what you're addressing now, Your Honor, are arguments that VSL itself never made at any point in time, not even in its appellate briefing, frankly. They're not saying they're not bound by the injunction. this is an argument that Your Honor is bringing up sua sponte. They're saying they're not bound because they shouldn't be held liable for.
I guess you're not appreciating my difficulty. My difficulty is VSL was a party. And whether VSL is in privity with the others or is aware of the conduct or should be attributed to the conduct was all taken into account when the injunction was entered. This is not where you enter an injunction against the parties and then the injunction reaches people who are in privity with them. This is a case where you have 3 parties and the court enjoins only 2. And then there's a motion to hold the 2 parties in contempt. That's all that could be done because the court deliberately excluded VSL and I guess they hold them in contempt based on VSL's parents' press release. That's the reach of this.
I think, Your Honor, I don't think that the court deliberately excluded anybody. The court was reacting to our motion, our request for an injunction. We requested that injunction against Alpha Sigma and Leadiant, but lots of other parties or persons could potentially be looped into such an injunction. That's
but why didn't you file a motion to hold VSL in contempt? I mean, VSL and
we did.
Well, at VSL you did. That's right. You didn't hold Leadiant.
Leadiant wasn't engaged in Leadiant sold its interests and left the whole scene years earlier. So they didn't do anything wrong with regard to complying with this injunction. But Alpha Sigma, Judge Quattlebaum?
Mr. Shulman, could I ask a different question? You've alleged several categories of conduct, and to me, and I realize you have an issue about whether they were argued below, and so I appreciate those issues. But on the merits, assume just for discussion purposes that I have concerns, or that we have concerns about the willfulness of the healthcare letter issue. So assume we have concerns on everything but the Facebook messages. Okay. Do you need us to find in your favor on all of the alleged contemptuous conduct or some of it? Help us understand what we need to find with respect to the varying categories of conduct.
Okay, so Judge Quattlebaum, as this court held in the Rainbow case that we cite, which is a 2018 decision, and also in the Klopp decision, which I believe is 2020, a single violation is sufficient for a finding of contempt. So where there may be half a dozen or a dozen alleged violations, we think proven violations, the court only need to find one to justify the finding of contempt. I would also note that we don't agree that willfulness is a required element. I think that's clearly not the case, as found in the General Motors decision of this court and various other decisions.
Can I follow up on that point, Mr. Shulman? So if that's true, then what about the concern that the order doesn't distinguish in terms of liability among the parties? You've got these 4 separate categories of allegedly contemptuous behavior, which can be logically attributed to one party. I think 3 of the 4, the party responsible was Alpha Sigma. The press release can be attributed to VSL, yet the attorney's fee award is lumped together. They're jointly liable. So isn't that concerning?
I think it's not concerning for a few reasons, Your Honor. Number one, they didn't contest that in the court below. So most of the arguments that you're seeing now raised were not raised before. And in fact, there has been briefing on the quantum of attorney's fees. And in their brief, they were arguing for a lower amount of attorney's fees, saying, and I quote, "The defendants were conciliatory and did not contest most of the alleged violations." That's page 701 of the joint appendix. So they didn't contest almost any of these violations in the court below, including on this issue that Judge Diaz, you raised, which is them being lumped together, which we did repeatedly in our opening motion on the contempt motion, because they do act in concert. As their counsel acknowledged, they stand shoulder to shoulder in the marketing of this product. They didn't seek to oppose our motion on the grounds that they shouldn't be lumped together, and now they're raising this as a post hoc reason to attack the contempt order. But I also would say, based on the principle, Judge Diaz, that you only need to find one violation to justify contempt, we have at least one violation against both of those parties. So we have the press release against VSL and multiple instances of direct violation of the injunction by Alpha Sigma. So I think it's material.
Is there any? I mean, I know you would. You're seeking contempt against VSL and Alpha Sigma. I mean, and think you're entitled to, and I appreciate the arguments, and we'll consider those. But what's the consequence if we decide, hey, I get your argument, they're acting in concert, but we just can't affirm a contempt order against the entity that had not been enjoined in the first place. And so we say maybe Alpha Sigma is subject to it, but not VSL. What's the practical harm to you of an order like that?
I think the practical harm, Your Honor, is that VSL the parties will then use that as an invitation for people like Mr. Guarna to continue putting out false advertising messages. So, I mean, I think it's important to remember this is a serious medical product. There is legitimate confusion in the marketplace. We put 2 affidavits before the district court showing people seriously harmed by this confusion. They were taking VSL until 2016. It was working fine when it was the original formulation, and all of a sudden, mysteriously, it stopped working. And people were really suffering as a result of that, not knowing why, until they eventually figured it out several years later. So it would be, we can tell you, because we've seen how aggressive and bold Mr. Guarna in particular can be. There was a second contempt motion that we filed, and it's not in the record, so I won't go into details, but this is a concern about whether Mr. Guarna would then feel at liberty to continue putting out press releases, mischaracterizing and confusing consumers further on the relationship between the new formula and the original formula. And I think the bottom line continues to be, Your Honor, it would also set, I think, a dangerous precedent, because it would essentially rewrite Rule 65. Rule 65 says that injunctions could apply to persons who are not named as parties to the injunction.
Yeah, but don't you, on that issue, I mean, I've looked at, I mean, I think that's right. I mean, certainly that's what the rule says, but aren't you obligated, and maybe I'm wrong on this, but did you categorize VSL in your motion for contempt as a party under Rule 65 in that fashion? Is that the way you?
I don't recall if we referenced Rule 65. Again, their counsel readily acknowledged that they're bound by it. So there wasn't a need to do that. But also Rule 65 itself says it's binding on those who receive actual notice by personal service or otherwise. So the rule is focused on attaching responsibility to those who have notice. It would be unfair, obviously, if people did not have notice of it, but no one can argue VSL was unaware of this injunction.
Right.
And they readily agreed that they were bound by it. So I don't think there's any unfairness to VSL, but on the other hand, there would be, I think, potentially dangerous implications for consumers and for Exegy. I mean, there's a reason this injunction was fashioned. This court, this panel affirmed it, recognizing that Exegy stood to suffer, had suffered, and would continue to suffer harm by this false association between the new formula and the original formula. And so, we would respectfully request that the court look at that and take steps to enforce the injunction in a way that Exege's interest and the interests of the public will be protected. I see I'm winding down on my time. I would say that it's important to remember, while there wasn't a finding of willfulness, because there didn't need to be in our view, the court did find that the violations were blatant and persistent, and that the efforts at compliance were, quote, notably deficient. The court found that it appeared the Alpha Sigma representatives were working off of a script, and this is a script that it had blatant, obvious violations of the injunction. So we're talking about parties who were very well aware of what the injunction required, and they allowed their representatives to engage in these blatant, notably deficient and persistent violations. So, why would we want to condone this kind of behavior? I don't understand, because and they raise a number of specious arguments, we contend, most of which weren't even raised in the court below. They suggest that somehow this amounted to a criminal contempt finding when they weren't given appropriate process. I think any reasonable reading of Judge Chuang's order shows that it was measured, it was limited, the relief was coercive and compensatory, not punitive. The order was very simple. Remove these references, which they largely acknowledge were violations. They said it was inadvertent. Now they're saying we didn't know what our own representatives who are managing the Facebook page were doing. I think the Rainbow case makes clear that we impute knowledge of one's own website, known web platforms to that party, and that's a constructive notice. Yes.
Let me ask one more question that's kind of going back. I just want to make sure I understand it. So it seems to me, with respect to VSL, we have the issue of whether they were enjoined in the first place, and then we have another issue as to whether the acts that they didn't do, say for example the Facebook conduct, is attributable to them. On this second point, is there any authority, or do you contend that for us to find VSL liable, we have to first say that under Rule 65D they're a party acting with concert? Then we look at the conduct attributable to them, which is the press release, and we can make our decision on that. Are you saying that even if we were to find the press release not sufficient to be contemptuous, that they should be held responsible for the other violations that they did not carry out?
We do say that, Your Honor. Number one, all of these arguments that you just recited were waived because they weren't raised in the court below, and some of them weren't even raised in the appeal. But beyond that, again, Judge Chuang incorporated into his contempt finding his prior findings. And those prior findings included determinations that VSL and Alpha Sigma were working in close concert with one another in the entire marketing effort. They had well-defined roles, but both of them participated in a coordinated manner in the marketing effort. So it shouldn't be a surprise to either of those parties that they would be held responsible for the actions of the other. And if you're going to oppose a motion saying there shouldn't be joint and several liability, you should be expected to actually raise that point in your briefing, and they never did. So with that, Your Honor, I see my time has expired.
All right. Thank you, Mr. Schulman. Let's go to Mr. Brennan. You're muted. Can you unmute?
Thank you, Your Honor. I apologize. I have to comment we repeated our assertion that the BSL-3 product is harming consumers based upon two affidavits when tens of thousands, if not hundreds of thousands of doses have been distributed and taken in the years since January 2016 And to say that two affidavits.
That's a difficult argument for you to make.
Yeah.
When you repeatedly go on in response to questions about the product, mislead the public. To me, there's no doubt that at least the Facebook left things in a state of confusion, which is demonstrable harm. It's the guts of the whole cause of action, and I think you're picking some of your very weakest arguments, but you can go ahead and make it. But
well, Your Honor, as far as the Facebook goes, I'll just leave it at there was no evidence, let alone clear and convincing evidence of any harm by the brief period of time it was up. As soon as they were notified, we took them down. With respect to the YouTube videos, we don't agree that those are Alpha Sigma's responsibility because most of them were put on YouTube at a time when Professor DeSimone was the CEO of VSL, going back to December of 2012. And most of those videos talk about the so-called DeSimone formulation. So, there's no misrepresentation, or at least no evidence of any clear and convincing evidence in this record of any misrepresentations with respect to any of those videos. But the fact is, they were posted 2.5 to 8 years, 7 years prior to the injunction. They were not something that we did after the injunction. And if you look at page 438.
Well, isn't the allegation that you failed to take it down?
The allegations we failed to take it down.
Well, that doesn't go to what you were just arguing. The question is, why didn't you take them down?
No one had, in 7 years of litigation, going back to all these videos were posted before the amended complaint. 2 years before the trial, no one ever
I'm granting you
this was harm.
Mr. Brennan, I'm granting you that, but I'd like you to address what defense do you have for not taking down the YouTube after the litigation was over and the injunction was issued?
It had not been on anybody's radar that these were causing harm because it had never been raised in 7 years of litigation. That's what I can say for that. With respect to the health claims letter, that was the evidence is that from our IT systems person took reasonable steps to make sure that letter specifically was not available to the public. It certainly was not readily accessible or directed to consumers after the injunction. Because counsel for Exigy was able to find it by searching on Google, VSL litigation does not change the fact that we took reasonable steps, and it doesn't mean that we violated the injunction. But with respect to the harm on that, there's no evidence that anybody saw it other than counsel after the injunction was issued. Same thing with the YouTube videos. There's not a single piece of evidence to show that anyone saw that post-injunction. But we took the health claims letter down the moment they told us that they had found this link. We figured out how the link worked. We took it down. They republished it. They filed it. They didn't file it under seal. Somebody searching today for VSL litigation-related documents can go on Pacer and get the copy that they filed in this court in the joint record extract or the record below. And it begs the question, if it's available through an obscure link that we failed to find, no one has identified a reasonable basis for what we should have done that we would have found it. That harms them, but it doesn't harm when they intentionally publish it.
All right. Let's hear from Mr. Broughton.
Yes, Your Honor. Thank you. I'd just like to address a few things that you all have raised in your questions. First of all, Rule 65 was not argued below, and there's no evidence that VSL and Alpha Sigma were acting in concert as it concerned any of the 4 acts of alleged contumacious conduct, nor are we responsible for Alpha Sigma's actions. And there's no evidence that we had anything to do with it. As to harm, which I know the court is focused on, the trial court at page 690 of the joint appendix note that it had inferred harm. And if you think about the injunction here and what it enjoined Alpha Sigma and Leadiant from committing certain acts. And so to infer harm from a Lanham Act violation, which is a preponderance of the evidence standard, when we've got a clear and convincing evidence standard of harm, and infer that regarding a press release that Actial, VSL's parent company, made, in which the trial court itself noted Guarna's statement was limited to a single occasion in a press release, not focused on establishing equivalence between VSL3 and the DeSimone formulation. And so the trial court itself has acknowledged that the very press release that's at issue here was not focused on establishing equivalence, which was the very basis for the injunction itself. I'm happy to answer any questions the court may have. Otherwise, we respectfully request that the Fourth Circuit, this panel, vacate the trial court's finding of contempt against VSL Pharmaceuticals.
Let me ask you, how do you take the statement that VSL acknowledged to the court that it could be held liable under the injunction?
So, Your Honor, that's found at pages 475 through 477 of the joint appendix. And in that, what Mr. Nelson, on behalf of VSL, acknowledged was that to the extent that it was acting in concert with Alpha Sigma, that it would be responsible for those actions. And so to the extent there is no evidence that any of these alleged acts of contempt were done in concert with Alpha Sigma. And so I would generally acknowledge that under Rule 65, assuming that had been argued that VSL itself can't go out and violate the injunction, there simply was no violation here. And again, it's not bound by the terms of the injunction itself.
Mr. Broughton,
right.
can I just follow up? Was that an argument made to the district court?
Your Honor, it was that argument was not made at the district court level.
All right, thank you.
All right, thank you, counsel. We appreciate your arguments, and as you know, the practice in the Fourth Circuit is to come down and shake your hands and thank you for your arguments and establish the professionalism of the bench and the bar. Goes back to Judge Parker in the 1930s, and we like that tradition. So this will have to serve as our greetings and our handshaking through the Zoom. It's not adequate, we know, but we'll see you again in court. Have a good day. We'll proceed on.
Your Honor.
Yeah.
Thank you, Your Honor.
We'll proceed on to the second case. All right, do I have Ms. Roush? Can you hear me?
Yes, Your Honor. Good morning.
Excuse me, Mr. Roush. And Ms. Marini, can you hear me?
Yes, Your Honor.
Okay, why don't we hear from Mr. Roush and proceed with your argument.
Thank you, Your Honor. Lee Roush on behalf of the appellants, Edward and Deborah Gellin. May it please the court. This case presents the question of whether the district court abused its discretion and committed reversible error in granting the motion to dismiss of the appellees, instead of granting an extension of time as it initially did. Notably, both plaintiff's expert in the case and the expert of the Baltimore County defendants agreed that the appellees, who were defendants below, had responsibility to safeguard the mental health and well-being of the decedent while she was incarcerated for 11 days at the Baltimore County Detention Center, and that a failure in those responsibilities contributed to her death. The district court here should be reversed for either or both of two reasons. First, on the record, the Gellins did show good cause under Rule 4M, and thus, under its express language, must have been granted an extension. Second, the district court erred in holding that it lacked the discretion to grant an extension absent good cause, despite this court's statements in at least 4 other cases in which it has said that a district court does have such discretion. Turning to the first argument, the district court erred in finding a lack of good cause, both on the original motion to dismiss and as to the Rule 60B motion for relief from judgment as to appellee Schumann. Rule 4M, of course, sets the time period for service and provides 2 alternatives that are on their face non-penal in nature if service is not made within that time period. The rule says that if service is not made within 90 days, then the court must either dismiss without prejudice or order that service be made within a specified time. If good cause is shown, however, the court must extend the time. This court,
counsel, could I just jump in and make sure I understand the timeline? Am I correct that the 90-day period under Rule 4M expired February 9th, 2017?
yes, Your Honor.
Okay, and your request for an extension took place October 6th, 2017?
Correct, Your Honor. And the circumstances of that, of course, are very important. Notably, the Gellens and their process server believed that they had accomplished service on two of the appellees, Schumann and St. Fleur, in December of 2016, within a month of the filing of the suit, when the Baltimore County...
Were they counseled at that time?
Well, I don't know that there's anything on the record that shows that one way or the other, but it is important to note that they share counsel with their employer, defendant.
No. Were the Gellens counseled? I don't know if it's you or someone else.
I misunderstood. Yes, Your Honor.
Okay. All right.
They were counseled at that time. Promptly on the filing of the suit, summonses were submitted to the court. They were issued. A private process server was promptly retained.
Right.
And the process server went to the Baltimore County Detention Center. And let's not forget, to be honest, even before a suit was filed, the Gellens made a Maryland Public Information Act request to Baltimore County requesting all of the staffing information at the BCDC during the time of her incarceration, and all records related to the psychiatric services provided to her, even before filing suit, trying to identify the correct parties and trying to obtain their location information. After suit was filed, the process server went to the Baltimore County Detention Center no fewer than 3 times. And on 2 of those times, on December 4 and December 8 of 2016, the Baltimore County Detention Center administrator took the papers for St. Fleur and Schumann. And I do think it's critical to note that that was after an earlier trip on December 1 to serve papers for appellees Sevier, Barr, and Titus, where the Baltimore County Detention Center staff specifically said, no, we can't take papers for these 3 appellees. They no longer work there. And then they went back.
Well, let's, as to those 3, let me just kind of break it down. For Barr, Sevier, and Titus, I'm not sure I'm saying that right. My understanding is you were informed, your clients were informed, the process server was informed in early December that they could not be served through the administrator there at the detention center. And I think the allegation is in December there was an effort to find their address. Is that right?
Correct, Your Honor.
And there was no belief, am I correct, that there was no allegation that your clients believe those parties had been served in December?
That is correct, Your Honor.
And were any steps taken between the address search in December and the request for an extension in October of the following year concerning those defendants?
The record reflects, as to those 3 appellees, that in addition to the Maryland Public Information Act request and the process server going to the Baltimore County Detention Center, when told that they were not employed there, he did inquire for last contact information and was not provided that. It's also shown that he performed a skip trace at that time and had no other information. I also think it's important to note
was that in December of 2016?
Correct, Your Honor. I also think it's important to note that during the 7 months in which their employer, Correct Care, was litigating the motion to dismiss, there had been no scheduling order issued yet, and so discovery had not started. And so there was no ability to serve interrogatories on any of the defendants at that time to try to obtain any additional information. But that is the answer with respect to those three defendants. And in fact, as the record reflects, when this was raised, after Correct Care's motion to dismiss had been granted ahead of a conference call with the court, it was raised at that time. It was explained to the court what the difficulties had been. The court advised to file a consent motion for extension of time, which was done. That was granted, and service of process was made on two of those appellees within the 30 days. It's also in the record that the Gillens did contend, and this is something that the trial court made an erroneous finding in its opinion. The trial court said that the Gillens never disputed that they hadn't served all the appellees, and they never disputed that service on Schumann and St. Fleur had not been properly made. And there was no such concession or admission by the Gillens. In fact, in their motion for extension of time, in their opposition to the motion to dismiss, and on the conference call with the court, it was explained that they did contend that service on Schumann and St. Fleur had been properly made. So that was an erroneous fact.
Mr. Roush, can I ask you about that? So I get that. I get that point that there may be, that was the assertion that was made, but the question is whether or not that's a mistake of fact or a mistake of law. The rules, the service rules seem pretty clear that in this context, that service on the administrator was not proper as a matter of law. So how does that amount? And in fact, if that's correct, then how does that make an argument for good cause?
Your Honor, I think that really cuts to the heart of this motion. Yeah, I think that cuts to the heart of this appeal. And I think that the commentary to the rules, I think the rules itself, the commentary to the rules, the advisory committee notes, and the cases lay out that there is a difference in a mistaken belief that there was service when in fact there had been no attempts whatsoever. So for instance, in this court's decision in Hansen, where there had been no good cause found, and there were various explanations given for that, but there were 15 months, there was no service for 15 months after filing. There was no service after 7 months after the transfer of the court from one venue to another. And the plaintiff had explained that he hadn't found new counsel and believed that the defendant had already been served. But in fact, there had not been any attempts at service. There's a difference between that and a mistaken belief that there was service accomplished. If you look at Wright Miller, for instance.
But counsel does, I mean, so assume a process server goes to someone's house and yells from the front yard, hey, Mr. Smith, you're served, and then gets in and leaves. Something that's plainly not service, and, then comes in later and says, hey, we thought we served them. It seems to me, to Judge Diaz's point, when something is not service and it's really not debatable that it's not service, I'm having a hard time determining, even if there was an attempt, that that's good cause.
Your Honor, in answer to your hypothetical, which is different facts here.
Sure.
That I think we could. You've come up with a hypothetical where clearly there was no service. Here, I think there is at least a basis for service, or at least I think it misses the mark to be arguing whether or not this service actually at the end of the day was correct. But the question is, was there some affirmative or diligent act to make service, and was there at least some reasoned belief that that could be accurate? And here, when you have a process server who goes on December 1, and when the Baltimore County Detention Center indicates that for certain of the appellees, they can't accept papers, but then on 2 subsequent trips takes the papers, and the process server puts in his affidavit, I believe that service was complete at that time. I think by negative implication, there has been some representation by the BCDC that service on those two key defendants had been proper. And if you look at the case law, if you look, for instance, at this court's decision in Scruggs, which quotes to TS Rentals, which also cites to Quan, this court has noted by citing these cases that there have been past instances of good cause found when a plaintiff immediately corrects what was found to be a technically flawed service.
Mr. Ross, can I, I'm sorry, I didn't mean to interrupt you, but I think I'm more interested in what I hope you're getting to now, and that is whether or not you even needed good cause under these facts, given the Supreme Court's, I don't know if you want to call it dicta statement, that the rule doesn't even contemplate a requirement for good cause in these circumstances. I'd like you to talk about that.
I agree, Your Honor, and I almost thought about starting that way. So alternatively, if the court finds that there is not good cause, or that the district court did not abuse its discretion in finding no good cause on some or all of the appellees, it should find that the district court's holding that it lacked authority to extend time absent good cause was itself an abuse of discretion. And we cited the court to a Third Circuit decision, Kane versus Abraxas, that says that making such a finding that it lacked the authority is itself an abuse of discretion. I think the conclusion, when I look at this court's decisions, prior decisions on this issue, I can see that there has been an evolution in the court. We start obviously with Mendez, which both sides started, and with that, which I think Judge Niemeyer is very familiar with, and we go all the way.
Yeah, but I'm not sure that has much vitality after Henderson.
Correct. So
it seems to me that if you assume, and that's what I want to ask you about, if you assume the district court thought it had to find good cause and didn't recognize it otherwise had discretion, then it seems to me you don't have much of a problem in persuading the court that the rule and the law probably allows both. In other words, good cause requires dismissal, but in the absence of good cause, there still is discretion, it seems to me.
That's absolutely correct, Your Honor. I think
all
that's
right. So now the question is, did the district court believe it did not have discretion, and explain why you say that?
Oh, it's right in its decision, Your Honor.
Well, that's pointed out to me. Yeah.
Okay. If I can get to the record.
In page around 259.
Thank you. My notes are that the same page, that it notes a split in authority as to whether Rule 4M gives discretion to extend, but it says that the more recent cases of the Fourth Circuit suggests that it does not have such discretion. But let me get to the actual language.
I see it here.
Yeah. So it's on page. It's on page 259.
Yeah, courts do not have the discretion to extend in the absence of good cause.
Correct. And I think
so counsel, can I jump in on this issue? Because if you're right, I mean, I think we have a situation where, Henderson speaks. We got Mendez, we got Henderson. There's a question of whether Henderson's dicta is enough to either overrule Mendez or make the logic of a reasoning of Mendez untenable. And let's assume we agree with you that effectively Mendez is no more. Would the result of that be we would send this back for the district court to evaluate in its discretion whether to grant the extension?
I think that's likely the result, Your Honor. I mean, we would first submit that we believe that there is enough on this record that the circuit court could order that on this record and under other cases, including Scruggs, which recognized, where there's been a technically deficient service that's been promptly corrected, that does satisfy.
We can't substitute our discretion for the district courts. In other words, we could exercise discretion, but that's not our role. our role is to determine whether the district court abuses discretion.
Correct.
And so it seems to me we would have to give the district court the opportunity to exercise discretion or not. If the district court said in these circumstances, I choose not to exercise my discretion, then we have the appellate issue would be whether that was an abuse.
I think
to
that,
ask us to exercise that discretion doesn't seem to be appropriate.
and that's why I started with, I agree that's the most likely result.
All right, you have some rebuttal, I believe. Why don't we hear from Ms. Marini?
Thank you, Your Honor. And I'm going to pick up on the issue of Mendez. In this situation, to answer the question posed by the panel, if Mendez was no more, we're in a situation where the district court has looked at this with discretion under a number of standards already. The district court has reviewed the good cause factors at length in a 4-page single-spaced opinion, has weighed those factors and has determined that good cause doesn't exist. It appears to me that virtually every factor weighs against.
Well, the rule would indicate if it's correct in not finding that the good cause was not shown, then that eliminates the mandatory aspect of the extension in the rule.
If that,
but the rule seems to have the alternative. It says the court may grant an extension, and if there's good cause, must grant it. So here, let's take your argument as adequate that good cause has not been shown. You want to affirm the district court. The district court didn't seem to recognize that it could assess that on its own discretion. With that one statement, it says there was a split, and it says that the recent cases of the Fourth Circuit and the District of Maryland say that that courts do not have discretion to extend Rule M deadline absent good cause. Now, would you agree that's an error of law?
Well, at the time this is written and today, Mendez remains the controlling.
No, I understand. I'm saying based on a total assessment right now on appeal, as we look at it with Henderson and all the other circuits and so forth, and looking at the rule itself, do you think that's an error of law?
I certainly understand the footnote in Henderson and dicta and that Mendez has been questioned. The situation the district court is in is that it is required to apply the controlling law of the circuit, which currently, until there's a reported decision that overrules Mendez, is a correct application by the district court of the law in the Fourth Circuit as it currently stands. In fact, the Scruggs decision that the appellants have been relying on reaffirms that Mendez is the controlling law despite questions until there is a reported decision by the Fourth Circuit.
So really this case comes down to whether Mendez should continue to stand. That's you may still, if it doesn't stand in view of changes, if it doesn't stand, then you agree the court would have to be given the opportunity to exercise its discretion absent the requirement of finding good cause.
Well, in this situation, we have a record where the court would need a reasoned basis to exercise that discretion.
But there's a lot of reasons there's a lot of reasons the court may or may not want to exercise discretion. I mean, I don't want to suggest any outcome, but one of the more powerful arguments is we're in a state where the statute of limitations has run. And we want to be pretty sure that the discretion is exercised with some sensitivity to that. But
and the district court has looked at that particular issue in the context of the Rule 60 motion as well, and has found that the appellants didn't demonstrate either excusable neglect or extraordinary circumstances, exercising its discretion subsequently under the Rule 60 motion. So this
Ms. Marini, can I follow up on that point?
Yes.
Isn't the best evidence that the district court might be inclined to exercise its discretion favorably that it did so once already?
That it did so once already, yes. the district court has looked at this on two separate occasions, both in the
I mean,
original.
it granted an extension early on, and this was after the time period for completing service had expired. It granted an extension based on a consent motion, and then at some point, I guess, when it was brought to its attention that there was a good cause requirement for granting that extension, it reversed itself. But it seems pretty clear to me that the district court is at least open to exercising its discretion in this case, and so why wouldn't we send it back to the court to make that determination?
Well, a point of clarity on what was captioned as a consent motion. These appellees were not a party to the proceedings at that point, did not consent to what was captioned as a consent motion. So after they were served, the matter was brought to their attention. We then filed the request that the district court revisit that preliminary decision to grant an extension with the full set of facts in front of it, including the timeline of delay that was available in this case. And it's a significant delay.
So counsel, I think that's perhaps a reasonable argument. I mean, Judge Diaz suggests the prior extension is evidence that the court's open to it. Your argument would be, well, at the second time the district court denied, there was good cause, and all those issues might play into the discretion. But it seems like if we assume that Mendez is no longer good law, it's a pretty big jump. It looks like the court in Scruggs kind of did that a little bit, but it's a pretty big jump for us to say we know that the district court would not exercise its discretion. And that's what it sounds like. If you grant that assumption about Mendez, you're asking us to do. You may be right. It may be that the length of the delay here is something that would cause the court not to exercise its discretion. But it seems like you're kind of asking us to get inside its mind. And maybe there's enough there for us to do it, but that seems like a tall order.
And I am not suggesting that Your Honor get inside the mind of the district court. What I'm asking is that based on the fact that the district court looked at this for the first time with the full facts in front of it on the motion to dismiss, revisited its earlier decision where it granted provincially the extension of time, revisited that, said, no, that's not what the court wants to do. And
no, Ms. Marini, what it said was there was no good cause for
correct.
It to do what it, and we're talking about two different standards.
It said that there's no good cause, and then in reviewing the Rule 60 motion, so then the subsequent request by appellees, the court looked again under whether there was excusable neglect.
That's an even greater burden. That's an even greater burden than good cause.
It is, and but it does show the consistency in the district court's rulings on the matter when it's looking at the same facts with the full facts in front of it on the issue of whether in its discretion there should be an extension of time.
But you're basically telling us to rule, and I'm now on the assumption that we conclude Mendez doesn't have vitality now. If we conclude that, then it seems to me the rule gives the discretion to the district court, not to the appellate court. And we could only guess what the district court would rely on or what it wouldn't rely on. There's a broad range of factors that a district judge can consider in determining whether to exercise discretion. And it may turn out that in this case, all the matters you pointed out for good cause are mighty powerful evidence to persuade the court to exercise its discretion in your favor. On the other hand, there are other factors too, but the court felt bound by the good cause standard. I think that's pretty clear from its opinion. And so if we say it's not bound by that standard, it could in its own discretion, without suggesting how it exercised discretion. We're trying to guess. I don't think we should try to guess. It seems to me we have to give the court the chance in the first instance to follow the law, right?
I think that's correct. And I think also that this is a situation similar to Scruggs, where the record doesn't identify any basis for the court to avoid the application of the rule. The rule still, Rule 4M still needs to have some meaning. The rule is there to be followed. There's a 90-day service deadline, and the rule already takes into account discretion by allowing the court on a case-by-case basis, as set forth under the case law, to determine whether there is good cause that would allow for an extension of time. So the rule itself tempered its applications to allow good cause, to allow a diligent plaintiff to ask.
Yeah, but under our assumption that the rule also grants discretion absent good cause, then the arguments that you would have to make would be focusing just on factors that would influence a court to exercise its discretion, persuade the court why it shouldn't. The court didn't feel like it was empowered to exercise discretion. It said it could only do so for good cause. Because it couldn't find good cause, it dismissed the case. But it seems to me the whole function is not an appellate function. The function is given to the district court by the rule. And our only thing we can do, since we don't know what the district court would do on its discretion, the only thing we could do is let the court give us the reasons, make its decision with under the right standard, and then determine whether it was an abuse. As you know, that's a different standard than reviewing good cause, I think.
Well, and the good cause finding is actually reviewed under an abuse of discretion.
Yes, of course, yes.
And here, we have a lengthy, well-reasoned opinion that goes through and identifies every single factor thoroughly, all of which weigh against the appellants.
Sure. And it may be, you may be right. The district court, if we were to say Mendez no longer is good law, and if we were to remand it, and those are ifs, we're not deciding anything in real time here. But if you're right, the district court will quickly rule in your favor, and we'd then review whether that was an abuse of discretion. You think the record's clear enough to tell us what the district court would do? That's basically what you're saying, right?
I think so, because there needs to be a reasoned basis to extend that discretion. Would it be an abuse of discretion for the court to grant an extension under these facts?
Then you're asking us, number one, to predict what the district court would do, and then number two, if it did the wrong thing, to find that prediction to be an abuse of discretion. We would have to perform both functions, right?
Well, there's been a finding by the district court of a lack of good cause and a lack of good faith by the plaintiff specific to serving Mr. Schulman. So Mr. Schumann, who you'll recall is one of the plaintiffs that the appellants claim that they believe to have been served through papers delivered to the administrator at the Baltimore County Detention Center. So the court has already found a lack of good faith on that issue, subsequent to the— Well,
you may find on other issues too. There's this big long delay as to the others, and you say, what was the attorney doing during this period? Why didn't he review the affidavits, the returns of service, and all these things? Was there a decent search made to find them? These are all very legitimate matters that I think you should be able to present. I'm just questioning how we should predict how the court will exercise discretion and then review that prediction.
I understand. And the record on those issues is complete, is determined. And so we know what happened. We know that there were very limited cursory efforts made. There were 3 defendants who were not served at all, and that there's no question that the appellants knew they were not served. And despite that, there was no request for an extension. There was no request for alternate service. there was nothing done simply for 7 months plus. And as the district court said, there was nothing revealed by the defendants. This was all within the control of the plaintiffs. So it's an issue where, you know, the lack
well, I hope you're making notes of this argument so you know how to do it, right?
Your Honor.
You're persuasive. I'm not suggesting. It's my whole suggestion is I don't think the rule gives us that discretion.
I understand your position, Your Honor, and I just do want to be clear on the issues that the appellants have raised of an abuse of discretion for the lack of good cause finding. The district court did not abuse its discretion. It went through every single element and factor set forth in the Scott decision at length. And the district court simply followed the rules. It followed Rule 4M, it followed Rule 4E on service of an individual, and that is not an abuse of discretion. On the Rule 60 motion, the same applies. The district court didn't evaluate the threshold requirement of whether a Rule 60 motion was appropriate at that time, because the court found that there was no excusable neglect, there was no extraordinary circumstance, and that encompasses that statute of limitations issue that Your Honor mentioned earlier. Statute of limitations alone and its expiration is insufficient to provide good cause for an extension.
Oh, there's no question about it. The statute of limitations gives a party long time advance notice about filing actions, and it's a bright line rule established by legislatures that courts follow. And anyway, we understand that, I think.
Okay, thank you. And if the court does not have any further questions, I will yield the remainder of my time.
All right. Thank you, Ms. Marini. All right,
Thank
Mr. Roush, you have anything further?
Just briefly, Your Honor, to address some of the things that came up in the argument. I think this court has recognized that Mendez, that there's been an evolution in the thinking since Mendez. There have been cases that have cited that the re-amendment of the rules in 2015 clarifies it even further and may actually have the effect of superseding that by rule. This court in Collins versus Thornton in 2019 noted that a plaintiff may escape dismissal for failure to timely serve process if she demonstrates good cause for the delay, or if the district court exercises its discretion to extend the time for service. I do think that the matter should be remanded to the district court to exercise its discretion. There are a number of opinions within district judges of the Fourth Circuit stating that the discretion would be that there would have to be some reasoned basis. And clearly you can see just from the back and forth this morning.
Well, my view of this record is there's a reasoned basis to go either way.
well, there you go. And so that's going to be something for the district judge. But it is noteworthy, as the court has already recognized, that they are different standards. The district judge specifically said at page 259 of the record that he felt constrained to find only good cause. And I think it is telling that the district judge did not say at that time that I find it doesn't make any difference that under any standard, I wouldn't have granted an extension. Didn't say that, and so the implication is that they may have thought differently. I think that is buttressed by the fact that when this first came up, they initially granted service. And there are, when you look at the cases on good cause and extending time in the circuit, and you look at other cases on motions to dismiss for insufficiency of service, you typically see a preference to have things decided on the merits. You typically see some second chance.
You do, but I don't think you can get a lot of comfort from all of those things, since whether you or your colleague or your predecessor, whoever, somebody has to attend to getting the case started. And that means either when I practiced as a lawyer, I did service many times by myself rather than hire a service processor. I remember doing it on a couple times where I knew it was going to be difficult and time was of the essence. But you at least, when you have a process server, you review the affidavits and you file them and you satisfy yourself you've got them served. Nothing in this case indicates that kind of care that was needed at that point in time. So that cuts a lot against those notions that sure, we wanted to decide the things on the merits. I think that's the whole process system's about, but we also have to have a process. And if we constantly tear down the process, then it's gone. And so these are things that I think you should argue before the district judge. And you heard some of the arguments already being made by Mrs. Marini. Is it Marini? Thank you. Anything else?
No, Your Honor, I will speak the rest
So
of
I want to thank you both. This is an interesting argument and raises interesting problems. And at this point, we would come down and shake your hands, and we missed that terribly. We'll resume that again as one of our iconic practices once we get over this COVID business. And but in the meantime, thank you for your arguments, and this little speech to you has to serve as our greetings.
Thank you. Understood, Your Honor.
Thank you to all of you.
Thank you.
Thank you.
All right. I don't know how my colleagues stand, but why don't we take a 5-minute recess?
Thank you. I'm going to ask the courtroom deputy to reopen court.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
All right, we'll hear the case of Muhammad versus Fleming, and Mr. Corzine, we'll hear from you or whoever you designate.
Thank you, Your Honor. I'm here to designate. Good morning, Judge Niemeyer, Judge Diaz, and Judge Quattlebaum. Under Local Rule 46A, it's my pleasure to introduce the Student Counsel who will argue both the opening and the rebuttal. His name is Blake Davis. He is a 3L here at the law school. He's editor-in-chief of our law review. Next, in the fall, he heads to Tallahassee for 2 years to clerk for a district judge and then a circuit judge. And that's my only bad news in this introduction, is it will be a judge in the 11th Circuit and not this court. But other than that, we thank you very much for this opportunity. I'm going to slide out of the way and turn it over to Blake Davis. Thank you.
Well, thank you very much. We look forward to hearing from him. All right, Mr. Davis, welcome to the Fourth Circuit. We'll hear from you.
Good morning, Your Honor. Thank you. May it please the court, my name is Blake Davis, and I represent the appellant Malcolm Muhammad. Under the Federal Magistrates Act, a district court judge may only transfer jurisdiction over a dispositive motion to a magistrate judge upon the consent of all parties. Absent that consent, all that remains is for the magistrate to issue a report and recommendation, and for an Article III judge, a judge of the court, to review it de novo. But neither of these two core procedural protections were implemented in Mr. Muhammad's case. And thus, Mr. Muhammad respectfully requests that this court reverse the district court's decision transferring jurisdiction over the motion for summary judgment to the magistrate judge for the following two reasons. First, because there was never simultaneous consent, and because Mr. Muhammad never consented to Magistrate Judge Sargent's jurisdiction, that there was not the necessary consent under the statute for the transfer. And second, that regardless of the status of Mr. Muhammad's consent, that the transfer was also improper because it was improper for the magistrate judge to review de novo her own report and recommendation when the act requires the review to be done by an Article III judge, which is consistent with this court's precedent and other federal statutes shaping the contours of de novo review. So to turn directly to the first point, Your Honors, under the text of 28 U.S.C. 636C2, even after a party has initially consented, they have the ability to thereafter withhold their consent, which is exactly what Mr. Muhammad did here, consistent with the local rule adopted by the Western District of Virginia to impose a 15-day window under which he would have been able to exercise jurisdiction of the magistrate if all parties had consented. And here there were four different
Mr. Davis, could I kind of get in at maybe this point? And, there's briefing about, the ability to withdraw consent and what standard would apply to that and what factors would apply to that. But I'm trying to figure out whether we actually have a situation where withdrawal is involved, or whether based on the notice that the district court provided, there's a 15-day opportunity for both sides to consent. And if both don't, that initial opportunity goes away, and then the court keeps issuing additional invitations. So do we have to talk about withdrawal at all? Or are we in a situation where the defendant never consented within 15 days? So we're not even worried about withdrawal because there was the first and second notices expired.
Judge Quattlebaum, that's exactly Mr. Muhammad's contention, is that under the Western District's rule, which was promulgated pursuant to Section C2 or 636C2, that the rule requires a 15-day window for all parties to consent. And after that window is lapsed, the consents that are given during that period expire, which was reflected in the notice that was provided from the Western District's clerk's office on the second consent form. It again instructed Mr. Muhammad that he had the opportunity to consent if he chose to, but that he could also withhold consent and that there would be no adverse consequences from the decision to withhold consent. And when the appellees did not consent in either of the first two windows, Mr. Muhammad chose to not give his consent when the third window was initiated in September of 2018. And so that's where, under the Western District's rule, which was promulgated to protect the voluntariness of the party's consent, it would be sufficient even without discussing the.
Well, let me ask you on this question a little bit. This is a local rule, and does it address, do you believe, the consent by the defendant or the mutual consent by the parties? In other words, I gather that the defendant timely consented. He signed a paper and sent it in twice. But the government never consented. As a matter of fact, it was a late consent. My question is, how is the local rule phrased? Does it cover the need to have both parties signing the consent form, or is it enough that the 15 days were satisfied by the defendant?
Your Honor, it does require that both. So here, Mr. Muhammad was the plaintiff in the 1983 action.
Excuse me, you're right. He's the plaintiff in the 1983, right? He consented, right?
He did, Your Honor, and it was not enough under either the statute, which requires the consent of all parties, or even just the local district court's notice in the Western District requires that each party has to send in a separate form notifying their consent within that 15-day window. And when that window had closed the first 2 times, that required the clock to reset and Mr. Muhammad to send in his consent again, which is also consistent with the text of Section C2, which says that even after a party has made their initial decision, they thereafter can make the decision to withhold consent, even if this court were to go beyond just the local rule imposed in the Western District, just in the statutory text. Because Mr. Muhammad withheld his consent before the government ever responded, almost a year after he notified the court that he would be withholding his consent, there would never have been the sufficient consent of all parties to transfer the jurisdiction.
Let me ask you if that's one way to approach it. And that's a very gets the process early on. In this case, it appeared to me that he withdrew his consent before there was a referral. There was no one else had reacted to the consent. The defendant had not reacted, and the court did not order the referral. A referral under 636C requires a court order, doesn't it?
A referral does require the court order, Your Honor, but it also requires
both consents.
Yes, Your Honor.
Yeah, and it seems to me that when we get to assessing whether a party can withdraw that consent before there's a referral, the rule does not have any provision of good cause. The good cause provision in the rule only applies to withdrawal of a reference.
Yes, Your Honor.
So the cases that are being cited in the briefs seem to focus on the withdrawal of a reference, which you need good cause for, but it seems to me it's an important distinction as to whether the person unilaterally made his consent timely, but there was no other consent, and before anybody else agrees or the court reacts and then there's no referral, he says, I want to take it back. And do we have case law that addresses that particularly factual circumstance? The Fifth Circuit, I guess. Yeah.
Not directly in the Fifth Circuit, Your Honor. The Carter case was dealing with a situation where there had already been a referral and all parties had consented. The only case that's analogous and a reported decision, the only one that's close would be the Gilmore v. Lockhart decision, where the Ninth Circuit was dealing with where one party, just like Mr. Muhammad, had withdrawn his consent before referral, and the other side had never consented one way or the other until much later on in the process.
Can you cite that as support for your position in this case, right?
Your Honor, we do as the most analogous to our position. We would also say that just as a matter of the statutory text, that we would, while the Ninth Circuit applied an abuse of discretion standard, we would say that he still had the right to withhold consent under Section C2 of the Act. That even after an initial decision had been made, he could thereafter withhold his consent. which is what, as a matter of just a legal error here, we would maintain that he did have the ability to withhold consent, which is what he did in October 2018.
Yeah, it's important, I gather, in the discussion of these issues is that courts take care to distinguish between consent and a reference. And a reference is a three-step process. It has party one consenting, the opposing party consenting, and the court issuing an order. That's a reference. But a consent can merely be the conduct of one party, and your argument is that in this case, he can withdraw that consent without the necessity of showing good cause.
Yes, Your Honor, and even more so that even beyond just the lack of consent here, that when we look to the timing in which the appellees, my friends on the other side, eventually tried to consent, that was almost 2 months after the magistrate judge had issued the report and recommendation in their favor. And as the Gilmore court said, there's a much lesser, in footnote 3 of the opinion, they talked about there not being any real issue of just selection among judges, because at that point, they knew exactly what the opinion would be. And then that was the type of situation the Gilmore court was trying to avoid. And we would ask this court to also follow that logic and reject the ability of a transfer once the report and recommendation had been done, both as a matter of the consent issue, but also, Your Honors, to address the second point that we mentioned in the brief. It was also improper for the magistrate judge to review de novo, assuming even if this court were to find against us on the consent prong. In the alternative, it was still improper for the magistrate judge to review de novo her own report and recommendation, because the Act makes clear that the de novo review must occur by a judge of the court, not as a separate entity from the magistrate.
Well, it seems to me when she became the district judge, de facto, she didn't need a report and recommendation. She was the recommender, and she's recommending to herself. And the report and recommendation, she could say, I agree with my own recommendation, but I think it would have been even cleaner in saying, I don't need a report and recommendation. I am the district judge now, and I'm making the judgment. I'm making the decision based on what I had recommended. I find difficult to see that there's any conflict there. She just, the recommendation process is sort of voided or merged into her ruling, because at that point, the recommendation is a recommendation to herself, and she knows what she's recommending. And it's not a conflict where it's not like her sitting on the district court and issuing a judgment and then coming up to the circuit court on special assessment and sitting on the review of that, deciding whether error was committed. The recommendations were what she believed was right, and she didn't need to follow the recommendations. She's going to follow her own authority as a district judge to make the ruling. I find your second argument a hard one to make, but I hear it.
Yes, Your Honor. Well, and it is in the alternative, because if Mr. Muhammad prevails in this court on the consent issue, then all that would remain at that point was for the report and recommendation to be remanded back to the district court for a review by an
Mr. Davis, can I, with respect to your first argument, if I'm understanding you correctly, it really doesn't matter why a party is withdrawing consent, or so long as the timing is within the, so long as the other side hasn't agreed within the time frame for acquiescing to jurisdiction by a magistrate judge, whether the party is acting in good faith, bad faith, or being indifferent. Because there's some suggestion in this record, and the district court judge pointed this out, that the reason why why your client was seeking to withdraw consent was that he was unhappy with some of the earlier rulings of the magistrate judge, and the court seemed to think that that was unseemly, that he could withdraw consent on that basis. But under your view of things, it really doesn't matter why the party is withdrawing, so long as it's done before the other side has consented and before the reference has actually been made. Is that right?
Yes, Judge. Yes, that is our position. I think we have, I guess, a twofold response. One, just as a matter of that, our position is that it could be for any reason or no reason at all prior to the consent of all parties, that the good cause standard would only be applicable once there had been the consent of all parties and the referral process begun, as in Carter, which was the distinguishing factor that the Ninth Circuit pointed out in Gilmore. But our second response there, Your Honor, would be that the Ninth Circuit went on to say that any issues about possible judge shopping, as my friends on the other side termed it in their brief, are lessened when only one party has consented. Because in this case, all parties knew the identities of the magistrate before choosing whether to consent or not consent in each of the 15-day windows. And Mr. Muhammad did not make his decision based on anything Magistrate Sergeant had done in this case. He did express, and as noted on page 498, I believe, of the joint appendix, that he was didn't want to do Judge Sergeant because of the rulings in a separate case. But even then, that would have been permissible because it could have been for any other reason or no reason before the court, Your Honor, as long as there had not been the simultaneous consent of all parties. And thus, Your Honors, because there was not the simultaneous consent of all parties in this case, there was not the requisite consent of all parties needed for the transfer to a magistrate judge. And moreover, Your Honors, in the alternative, we also maintain that because the section B1C requires a de novo review by an Article 3 judge, if there is going to be a de novo review, that judge has the ability to transfer back to the original magistrate for additional fact-finding. Mr. Muhammad respectfully requests that this court reverse the decision of the district court transferring the jurisdiction and remand for further proceedings. Thank you.
All right, thank you, Mr. Davis. We'll now hear from Ms. Tashima.
Good morning, Your Honors, and may it please the court. Rohini Tashima for the appellees. The issue on appeal is whether late Judge Kaiser abused his discretion when he denied Muhammad's attempts to claw back his knowing and voluntary waiver of his Article 3 adjudication right purely because he disliked Magistrate Judge Sargent. Judge Kaiser acted well within his discretion when he determined—
Counsel, could you, I don't know if you're far away from your microphone or something, but I'm having a little trouble hearing you. And so if your earphones, maybe just speak up a tad, I would appreciate that.
I'm sorry, Your Honor. Is this any better?
That's a little better. It's still a little faint. I mean, I can hear it if that's all it does.
You mean that little thing is your microphone?
I'm afraid so, Your Honor. I can try unplugging it and seeing if the computer might.
That's better now. What you're doing now is better. So
okay.
I don't know
I will
what
stay
you
as
did,
is
but
then.
Sounds great. Thank you.
All right. I'm sorry, Your Honors. And please let me know.
Just interrupt you so we don't use up too much of your time on things that we already understand. The question really in this case is whether the district court thought it had, it required good cause to withdraw the consent. It seems to me from a first blush, and I'll hear from you, but the first blush is that the word consent and reference are being blurred. Even the Fifth Circuit case where there was a total reference talked about the consent. And in this case, while the plaintiff did sign his consent, it did not have the effect of a reference. And only if you withdraw a reference do you need good cause. But the district court seemed to think good cause was the standard. And because the plaintiff here didn't show good cause, he couldn't withdraw his consent as opposed to his reference. Where did he get the good cause standard from?
Your Honor, he did look to the Fifth Circuit's decision in Carter. However, as a preliminary matter, the defendants would just like to clarify that despite Muhammad's contentions in his briefing, Judge Kaiser did not subject him to extraordinary circumstances, which came out of C4. To the extent that Muhammad argues that he imported the standard from Section C4, the C4 requires that to vacate a referral sua sponte, the court must look to good cause. But if a party moves, it's extraordinary circumstances. If Judge Kaiser had enforced the standard, he would have required extraordinary circumstances, but he did not. To the extent he used the words good cause, that he did cite the Fifth Circuit's decision in Carter, but Carter explicitly stated afterwards, determination of which is subject to the district court's discretion.
Kaiser, there was a full reference. And Kaiser, the holding was you could not withdraw that reference without good cause. And of course, that's the language of C4. But in its language in the Fifth Circuit, they loosely referred to that reference as consent. But the consent being discussed there was a full reference. Now, the question is, Gilmore seems to be more analogous because there had not been the reference there. How do you, if I'm right about that, how do you explain that?
Yes, Your Honor. To the extent that Carter did say good cause, all the cases it cited on just analogize to other cases from the circuit that explicitly state that it is within the district court's discretion to determine whether or not to grant a motion to withdraw a waiver.
Why should the district court have discretion at all?
Because, Your Honor,
if somebody sends in a consent form and then the very next day says, I made a mistake, I withdraw it, you think the district court has authority to say, no, we've got you?
Yes, Your Honor, because the right at issue here—
Where does that authority come from?
From Section 636, Your Honor, and how we treat waivers. The right to consent here is not the right to withhold consent. The right is the right to Article 3 adjudication.
Well, let's make it more dramatic. We're in court and the plaintiff says, I consent. And then he says, oh, I meant to say I do not consent in the same sentence. Are we going to hold him to that and have the court say, oh, no, you said you're going to consent?
Well, this is up to the district court's discretion, Your Honor. If it is purely the plaintiff misspoke, then perhaps it was an abuse of discretion to not allow the plaintiff to withdraw that waiver. But once a party waives—
Pretty steep hill there.
Well, Your Honor, once the party waives the right here, the right to Article 3 adjudication, that waiver is locked in at the time of waiver. It is not contingent on anything else.
He purported to exercise a right, but he never did because the right depended on two more acts, that is consent of the other party and a reference. And so the party here is intending to initiate the process for a reference by giving his consent, but it never happened. And he said, I'm changing my mind, I'm withdrawing my proposal of consent. And you're saying the court has discretion to say, no, you can't do that now, you're stuck, even though the court's never heard from the other side.
Yes, Your Honor. It's because the waiver analysis is separate from the transfer analysis under Section 636. Parties have the ability to waive their right to Article 3 adjudication independent of what other parties are doing. Each party individually makes this analysis and determines whether or not it wants to waive its right. It is only when all parties individually reach this decision that Section 636's transfer provision is triggered. Even under Section 636, district courts aren't required to transfer cases to magistrate judges. The parties can choose to waive their Article 3 adjudication right, but it is up to the district court's discretion whether or not—
Would you agree the waiver that you're arguing for is the waiver of a constitutional right?
The right to Article 3 adjudication, yes, Your Honor.
Yeah, and so your suggestion is a party submits a waiver of a constitutional right, and then before anybody else reacts, he withdraws that waiver. And you're saying he's stuck with it unless the court gives him discretion to do it. That's your argument.
Yes, Your Honor. And this is consistent—
Do we have a case that says that?
No, Your Honor.
Waiving a constitutional right? I mean, he had a constitutional right to a jury trial, didn't he?
Yes, Your Honor.
All right. And you're saying he sent out a notice consenting to waive that right. And then before anybody did anything, he withdrew it. And you're saying he's now stuck with the waiver of a constitutional right because the court didn't approve it.
Only if the court abused its discretion, and Judge Kaiser did not in this case. Judge Kaiser saw that the face of the motion explained that the only reason relief was sought was because Muhammad did not like Magistrate Judge Sargent. It cannot be an abuse.
So, counsel, let me ask you that. I mean, what's wrong with a party deciding, based on experience, I question whether I'll get a good shake from this judge saying, hey, I don't want to consent to that. I mean, it's presented as if it's automatically bad for a party to say, if I have a choice, factoring in my experience with a judge is somehow improper. Well, that may, in an appellate sort of arena, that may seem bad, but I mean, that happens every day, everywhere around this country. I'm just having trouble seeing the sinister or even questionable aspect of deciding not to agree to something because they have questions about whether they'll come out, as good with that judge versus someone else?
Your Honor, because Muhammad had affirmatively waived his right before it was assigned to Magistrate Judge Sargent, he did have to seek permission to call it back. If he had recalculated, if he had not already waived that right, it would perhaps be a different decision, because under Section 636, he can waive at any point. However, even if this court disagrees with Judge Kaiser's decision that he would not use his discretion to allow waiver on the ground that of dislike of Magistrate Judge Sargent, it can't be an abuse of discretion for a court to see that.
It just seems, somewhat, somewhat ironic that, the defendant, which never timely consented, and only consented after they get a, favorable R&R, is somehow arguing gotcha with the other party who, one way of looking at it is they didn't consent at all to the operative notice. And another way is they may have consented, but they withdrew it well before anything happened. Anyway, the facts here just are, seem to suggest the defendant, quite frankly, is the one chopping more than the plaintiff.
Your Honor, as a preliminary matter, this 15-day time frame is not included in the actual local rules. It is a court request that is included on these notices, and judges in the Western District frequently transfer cases after receiving waivers of these rights outside of the 15-day notice. These notices are even included on the Western District of Virginia's website for parties to fill out at their leisure at any point in time 24/7 and to submit to the clerk's office. It was within Judge Kaiser's discretion to decide one way or the other whether or not he wanted to accept that waiver from the Commonwealth, from the defendant at that time, and go ahead and transfer the case. But this is up to Judge Kaiser's discretion. If he had said no, it would not have been an abuse of his discretion in that instance either. The timing is somewhat atypical, but this does happen where a magistrate judge has already issued an R&R, and then the parties, Let
me ask you this. In civil process, under the rules, there's a specific rule that requires you to demand a jury trial. And a plaintiff files a lawsuit and fails to demand a jury trial. And then 2 days later, files an amended complaint that demands a jury trial. Do you need discretion of the court to do that?
I believe it would depend on the timing, Your Honor, and on whether the amended
2 days later, files an amended lawsuit demanding jury trial.
I believe that would be fine, Your Honor, because the amended complaint was filed within the time. I think the jury trial waiver is triggered based on the last pleading. But even to the extent that if the parties are at the level where they have all agreed to waive their jury
trial. But under your jurisprudence, you would say when they file that complaint, they waived a jury trial. And the rule would say that unless you demand a jury trial, it's deemed waived. Now, so here, the plaintiff filed a consent waiving a jury trial. And then before anybody does anything, he withdraws that and said, I want a jury trial.
No, Your Honor, because under Section 636, there's no other indication of timing. It's not contingent on refiling a complaint. Under Section 636, you have the right at any point before final adjudication to waive your right to.
There are fewer rules under 636. The only rule is after a reference, you need court intervention with good cause. It says nothing about withdrawing a consent from one party. It doesn't have a timing on it. It doesn't have a consequence. It doesn't say he sends in his consent and he's all bound by it. I don't know where you have a limiting principle to your argument about the waiver of constitutional rights.
Within this context, Your Honor, it is up to the court's discretion, but 636 envisions this where it insists on very specific
where does the court get the discretion to deny him the right to change his mind before anybody else? What rule or what principle?
It is within the case management, district court's case management decisions. They are given a wide degree of latitude in these areas. And Judge Kaiser was well within his discretion when he saw Muhammad.
What's your best case? Do you have a single case where somebody filed a consent and then withdrew the consent before the other party consented and before there was a reference?
I believe Gilmore is the most analogous, Your Honor, like Muhammad
Well,
states.
Gilmore goes against you, right?
Well, no, Your Honor, because it says whether to grant a motion to withdraw is a decision best left to the district court. A decision best left to the district court's discretion. And in this instance, it was within Judge Kaiser's discretion to consider the face of Muhammad's motion, a frequent litigator who he knows has appeared in this court 18 times and knows the magistrate system well, to look at his motion where it said that he disliked Magistrate Judge Sargent and conclude that it wouldn't be, and conclude that he would deny his motion on that ground. Even if this court disagrees, it can't be an abuse of discretion for a judge to say that a motion that explicitly states dislike of a specific judge is not an appropriate reason to call back a knowing involuntary waiver. That can't be an abuse of discretion. And because Judge Kaiser did not abuse his discretion there, it was up to Judge Kaiser to decide whether or not he wanted to transfer the case on these facts. In his transfer order,
the Constitution gives a litigant the option to try a case before the court or before a jury, as long as it involves $20, I guess it is. I come into court and I see a judge who has no experience in antitrust cases, and so I demand a jury trial. I'd rather try my case to a jury than that judge. Or that judge has taken a strong position in antitrust cases, and that happens to be a real life example. There's been a huge debate when I was a lawyer as to whether you try antitrust cases before a jury or to the judge. So one of the sides would say, these judges who have formed their opinions on antitrust law and the theories of economics and so forth, they don't happen to agree with it, and they'd prefer to go to a jury. Now, is that pernicious?
No, Your Honor, if they haven't already waived their right to a jury trial. I think the issue it comes down to here is Muhammad.
Yeah, but you're saying the simple filing of a paper is a waiver without any rule or basis to say it is a waiver. I mean, a waiver has to be a conscious knowing relinquishment of a right. And here this man said, I'm happy to go with a magistrate judge. There are practical reasons for doing that. And then he sees who he gets and he said, no, I'm changing my mind. And no one's done anything. And you're saying he's now bound by his initial paper unless the judge authorizes him to do otherwise.
Yes,
that's
Your
your
Honor.
position, right?
There's no contention that Muhammad's waiver was not knowing and not voluntary. Muhammad has gone through the system multiple times. He has had a previous case where the case was assigned to Magistrate Judge Ballou first and then subsequently transferred to Magistrate Judge Sargent. He knows this is a possibility. He made his calculation, decided when the case was still assigned to Magistrate Judge Ballou that he would like Magistrate Judge Ballou, or any magistrate judge rather, to hear his case. It was only after this case was reassigned to Magistrate Judge Sargent that he tried to claw back his waiver. His waiver was not with respect to Magistrate Judge Ballou specifically hearing, adjudicating his claims. It was to any magistrate judge. The mere fact that the case was that the case was reassigned to Magistrate Judge Sargent does not render his knowing and voluntary waiver somehow any less knowing or any less voluntary. There's been no contention in the record to support that. And Judge Kaiser was within his discretion to see this litigant, who he knows for a fact has gone through the system multiple times, has consented in other cases to magistrate judge adjudication, and has seen that his previous cases can be reassigned to different magistrate judges. It was not an abuse of discretion for Judge Kaiser to look at that and see Muhammad's reasoning.
Did Judge Kaiser think he had to find good cause?
I don't believe so, Your Honor. He did cite the Fifth Circuit's decision, but the Fifth Circuit was looking at a distinct situation, but made clear that this is a decision best left to the district court's discretion. And that's exactly what Judge Kaiser did. It can't be an abuse of discretion for Judge Kaiser to look at Muhammad saying, the only reason I want to call back my knowing involuntary waiver is because I don't like Judge Sargent. It can't be an abuse of discretion for Judge Kaiser not to agree with that. And to the
Mr.
extent—
Shima, can I ask a question about the notice? You made reference to the fact that this notice is purely, discretionary, that the 15-day requirement for responding is something that's routinely ignored in the Western District of Virginia. First of all, I don't know that there's any evidence of that in the record. I mean, we typically take deadlines and notices pretty seriously. I mean, it says pretty clearly that if you desire to consent to this action, you have to indicate that by signing it within 15 days of the notice. And in this case, your clients did that, failed to do that not just once, but I think 3 times. I mean, why shouldn't we hold you to that?
Your Honor, because to waive the right to Article 3 adjudication is not on a timeline. The parties have the ability to—
Sure it is. It's, I mean, the court has said it's on a timeline. It says right there, you got to consent within 15 days of the date of the notice. And if you don't, then the ball game's over. And the fact that they kept sending out these notices and your clients kept ignoring it, I mean, why should we ignore that?
Because it's a court-imposed request, and the district court has discretion to accept.
A request, really?
Yes, Your Honor. Also, this form is on the Western District's website for parties to fill out at any point. As a practical matter, the clerk of court will issue this automatically on multiple occasions. It goes to all parties. And it is within the court's discretion to decide, even if it's coming in after 15 days, it is within the court's discretion to decide if it wants to.
Well, did Judge Kaiser address that issue? He didn't talk about that at all, did he?
Your Honor, he stated that he had reviewed the record, which necessarily includes this timeline. And this court takes judges at their word. And because Judge Kaiser did review the record before transferring, that includes this timeline. And he decided it was well within his discretion to go ahead and transfer the case on these facts.
Let me ask you just one question as a follow-up to what I asked you earlier. I'm looking at Judge Kaiser's motion, and he says motions to withdraw consent to trial before a magistrate judge may be granted only for good cause. And then he says Muhammad has made no such showing, and therefore mere dissatisfaction with prior rulings alone is not sufficient to show good cause. Sounds to me like he thought he had to find good cause, didn't it?
Your Honor, the subsequent phrase after that is determination of which is within the district court's discretion. District courts make these decisions all the time, like balancing factors such as— I'm
asking you what the decision in this case made by Judge Kaiser was. Did he believe he had to? There had to be a showing of good cause?
I don't believe so, Your Honor.
Well, so we should ignore that statement in his opinion, his reasoning. He says motions to withdraw consent to trial before a magistrate judge may be granted only for good cause. And then he says Muhammad has made no such showing. And then he explains that Muhammad's reason is not good cause. Now, do you think he didn't rely on good cause or thought he had to when he says only for good cause?
Your Honor, to the extent this court believes he applied a higher standard, even then it would be harmless error, because under any standard, attempting to claw back a knowing involuntary waiver purely because of dislike of the magistrate judge, it can't be an abuse of discretion to say no to that.
All right.
If there are no further questions.
Yeah, thank you very much. We'll hear from Mr. Davis.
Yes, Your Honor. We're going to try to make just a couple brief points on rebuttal. And so I want to start, I think, just where my friend on the other side left off about the local rule and the applicability of the 15-day window. It is a requirement under the Western District's own practices that it is a 15-day window. There's nowhere in the joint appendix of the record does it indicate that is a commonly ignored practice. And even if it were a commonly ignored practice, to Judge Nehmeyer's point earlier about the constitutional right to an Article 3 judge, if it was routinely ignored in the Western District, then that would even make it more so heighten the importance of enforcing that window, which Congress in Section C2 went on to say that, or 636 C2, excuse me, went on to say that there would be rules adopted by the local courts to protect the voluntariness of the party's consent. And the advisory committee note to Rule 73 of the Federal Rules of Civil Procedure, which guides the process of full consent as a baseline, says that the local courts will primarily be adopting rules for voluntariness designed around the timelines upon which parties can consent, which is exactly what the Western District did here. But even to answer Judge Quattlebaum's question about the two different, or his point about the two different prongs, even if this court were to not determine it on the basis of the 15-day window, the statutory language still says under Section C2 that after they made their initial decision, that thereafter they can withhold consent. And so for that reason, Mr. Muhammad would still be able to have withheld his consent here, since there was never simultaneous consent of the parties. And as Judge, to answer Judge Niemeyer's question about where the good cause standard applies, the good cause standard only applies under Section C4 once the referral has already been made. Here, there was no referral that was made, and because there was never the consent of all parties, and thus any good cause standard that was relied upon in the District Court Judge Kaiser's opinion on page 414 of the Joint Appendix, clearly where it was on the basis of good cause. It would not be harmless error in this case, as my friend on the other side maintained. It would be a legal error and thus subject to reversal and remand on that ground as well, Your Honor. And thus, if there's no further questions, I'm happy to take any other questions the court has, but if not, we just respectfully request that the court reverse and remand for the proceedings before an Article 3 court.
Thank you, Mr. Davis. We would normally come down and greet counsel, and especially a student who's argued before us. Is this your first time in arguing under this in the clinic?
It is, Your Honor, in any court.
Well, you're going down to the Florida for a while, but we hope you come back to the Fourth Circuit and argue some more. You've done a fine job. And thank you, Ms. Tashima, for your argument. This has to be a substitute for our greeting to come down and shake hands, which is our normal practice. And so we look forward to seeing you both again. Ms. Tashima, you are in the Fourth Circuit, right?
I am, sir. I'm with the Attorney General's office.
Yeah. So we have you there, and we'll bring Mr. Davis back, and we can resume at another time. Anyway, many thanks.
Ms. Tashima is actually where we want to be in Richmond, but I think.
Well, it's good to have you. Anyway, we'll proceed on to our next case. Many thanks.
Thank you.
If counsel in 1921-86 could unmute their video.
I think I see both counsel, and I'll call the case of March versus Day Development Company. And Mr. Marcus, you can begin when you're ready.
Thank you, sir. Good morning. If your honors, please, we are here today to challenge a decision that was rendered by the District Court in Baltimore. There are two principal bases upon which we challenge the court's ruling. One is on what we believe to be an improvident grant of summary judgment in the case. And then the second is the calculation of damages, where we have a contract that embraces all of the terms that are necessary. I'm not going to spend a lot of time here. There were motions for summary judgment that were filed. The court granted summary judgment based on the court's perception that there was a breach of contract or two of
counsel.
Yes,
counsel, when I could hear you well when you started, but you backed up, and I appreciate it if you could kind of stay a little closer. Thank you.
I'm sorry, Judge. I've got.
That's okay.
I'm sorry. So
no worries.
Thank you. The issue here is whether or not the court improvidently granted summary judgment on the two breach of contract counts. The court has had an opportunity to take a look at what the original allegations in this case were. And the original allegations for breach of contract related to the fact that Day Development had not taken steps, contractually mandated steps, to market the property and or to develop the property. As the court has seen, there are two agreements. They're very similar in form. One was drafted and executed in 2003. The second was in 2005. there were 2 parcels of property that were at issue. The district court went through some examination of what the underlying facts were and came to some conclusions which probably are a good roadmap. There are a couple of things that I would like to point out to the court before I get into the nitty-gritty of this. These properties are located west of Frederick, the center part of Frederick, Maryland. They are properties that are on the fringe of development, and this was a planned neighborhood development that had been scheduled. The 2 parcels at issue here were parcels that were not originally scheduled for development. As the court is aware, in many developments like this, there are schedules and phasing that goes on. The 2 parcels, in this case, one was originally planned to be a domiciliary care parcel. And what that basically means is, as part of the planned neighborhood development, the original plan, which preceded day development, it was actually processed by Mr. March and his group, incorporated this domiciliary care parcel, and the domiciliary care parcel was essentially assisted living and for seniors and the like to complement the community. The second parcel.
So, counsel, if I could interrupt you here, and I appreciate you going into that background, but I gathered a good bit of that from the brief. So I'm going to kind of dive into the contract if you would help me with that. As I understand your argument, first of all, you think the contract is clear and unambiguous in your favor?
I think it's clear and unambiguous in these legal proceedings. To the extent that it favored us or favored the appellee, what it did.
Yeah, I didn't mean that. That's fair. But your argument, as I understand it, is that, and I'm just going to talk about the consulting services agreement because it seems like it applies to both ones. But your argument is that the compensation for obtaining approvals, there's 2 methods of that, and they're 4A and 4B, correct?
Yeah, I don't remember the paragraph because they're 2 different agreements, but yeah, there are 2 different methods.
That's fine. That's fine. And so, yeah, the question I have kind of relates then to C, because C then goes and says again that in the event the approval is obtained, compensation is due as described herein, due and payable, blah, blah, blah. And then it refers to the, in the first subsection to the sale, kind of which tracks 4A, and the second subsection to the building, which tracks 4B. And if it stopped there, I think your argument would be pretty powerful. But then it's got this, third subsection, which says January 1st, 2015. And it says that they get paid on the earliest of these 3 events, which seems to contemplate you could get paid on January 15th, even if those 2 other events, sale or building, hasn't happened. So how do you square the fact that 4C calls for compensation before sale or before development with your notion that those are contingencies that have to occur?
So what happened here is this is a development, and obviously it's a long-term project, long-term from the standpoint that the commercial parcel that was here could not be permitted, could not do it. It was prohibited unless and until infrastructure and roadways were in place. The trial went on. You couldn't get a building permit. And as the court, based on your questions, Judge, it appears that the court understands the difference between entitlements, which would be a paper approval on a plan, versus a building permit, which requires the installation of all of the infrastructure. So it's not just, go ahead, I'm sorry.
No. I got your argument, and I think that, you may have a very good argument that it was either impossible or very, economically unwise to sell or build at that time. But I'm just trying to read the contract, And the contract seems to say it. Yeah, I mean, there's nothing expressed that says you get compensated on January 1st, 2015, so long as it's not unfeasible to either build or sell. So it seems like you're trying to create a contingency in there that isn't there.
So there are different ways to be compensated for services. This is a consulting services agreement.
Yes,
the compensation that was due under this agreement arose in two spheres. One, if there was an out sale of the property during that period. If there's an out sale, everybody understands whatever the value is, it's all determined at the closing, the settlement goes on, and we know exactly how much money is there. If indeed the purchaser, Day Development, elected to develop the property, to go ahead and get building permits and to build whichever of the two projects were there, if they intended to do that, then there was a formula that said what the valuation would be at the time that those events took place. So
well, what's the point? Counsel, I think I understand that your two arguments about the two formulas, and I think that's a strong argument. But what purpose then does 4C, 3 small i's serve?
So, Judge, what I would tell you is when this case was first filed, there were other counts in the complaint, one of which was Quantum, Maryland. So let's assume that this is a traditional services agreement, a consulting services agreement. The case says that this gentleman went out, was a resident in Frederick, had opportunities in order to advance some land planning changes. He got the domiciliary care.
You know, I want to cut in because I'm interested in the questions that Judge Quattlebaum asked, but you don't want to talk about the contract. You're talking about circumstances. It looks to me, if you read the contract and you look at paragraph 4, that's the paragraph we're dealing with. Yep. The very first sentence of paragraph 4 says, in the event that Martz obtains the approvals, then he's going to be entitled to payment as indicated. So that's the condition precedent, obtaining approvals under the contract. Then it says it provides 2 methods of calculating, that's A and B, 2 methods of calculating the compensation. And it does not provide a method of calculating the compensation if nothing happens. It just provides in case there's a sale or there's building. And then C says when the compensation has to be paid, and it says the earlier of 1, 2, or 3. And 3 happens to be January 1, 2015. So you start with 4, first sentence, did he get the approvals? Everybody consents, agrees he got the approvals. So therefore, the contract says he's entitled to compensation. Now the question is how much. A and B provide calculations to how much in one contingency and in the other. And then C provides when you get the calculation. And with respect to the permits, it'll be on that date. With respect to sales, it'll be on that date. And if it doesn't, neither one of those happens, then it's on January 1st. It says the earliest of those 3. And so now the contract leaves open one big critical component. And that is, what if there is no sale and there's no development with permits? How do you compensate for getting the allowance? And the district court said that was an omission in the contract and applied unjust enrichment. And instead of following the compensation pattern in the agreement, the court said, I'm going to give Martz the fair value of the approvals. Now that's the structure of the way the contract worked. Now you can argue defenses, but I'd like you to first start with the contract, because the contract's a consulting contract. And it looks to me like Mr. Martz is entitled to compensation if he got the approvals. And he got the approvals. So the real open question is, how do you compute his compensation? And since the 2 contingencies did not occur, and they don't have a formula for when you just hold on to the property, the court said, well, the contract doesn't provide the amount, but he doesn't get away scot-free. I mean, we have $1 million worth of value given to the property. And so the court said, I'm going to determine the value of the property before the approvals, and I'm going to determine the value of the property after the approvals and give Martz the differential. And that's the long and short of what the district court did. And so you have defenses and you say, number one, the development could not have occurred. Well, in that case, you come under the January 1 payment date. He did see the approvals. So the only open question, you have the fact he's entitled to compensation. You have the date for payment, but you don't have how to compute that payment in the contract. And that's where the court supplied unjust enrichment, which now takes you out of the contract and goes to the value of the approvals. And the court determined that by the differential between value of the property before approval and value after.
Judge,
isn't that what the court did?
It did, but the problem with the analysis is if you look at 4B applies if Martz obtains the approvals, and then there's a conjunctive and DDC obtains building permits. Okay, that was required. Now you couldn't get a building permit.
That's required for compensation calculated in that fashion. The introductory clause up above says shall be calculated. And so if it occurs that you get building permits, then he gets compensation as in 4B. If he sells if the property is sold, he gets compensation in accordance with A. If the property is just held and there's no sale and no permits, it's silent on the compensation. But then it says on a C, it says then when the payment is due, and it says with respect to sale when the payment's due, with respect to permits when it's due, and if neither one of those occurs, it says by January 1, 2015. Now, as I point out, there's no calculation provided, or if you just hold the property.
So the issue here is, when this suit was filed, a quantum merit claim was made. The value of the services that were provided by Mr. Martz. It was contained in the first complaint at count 4, quantum merit. It related to the valuable services that he provided. So if everything that we've just gone over was what is the value of Mr. Martz's service? And so at that point, if this analysis is to apply, and we know what the law in Maryland is, I suspect it's...
Well, I don't know if you do know what the law in Maryland is, because the Maryland law says if the contract omits a provision that related to the subject, that the court can use unjust enrichment. And that's what the court relied on.
And there's case law that says, while that is a possibility, there are no cases under these kinds of facts that have used unjust enrichment. If the court takes a look at paragraph C and goes to the section right underneath it, and what it says is obligations of DDC to pay compensation to Martz shall survive the sale of the commercial parcel and any termination of this agreement. So what happens here is if you took the position that it was January 1st, 2015, the very next paragraph says that obligation survives the termination of the agreement and shall be binding on the transferee after that. There was a lien that was recorded as a result of this, granting an equitable interest to Mr. Martz. So to the extent that Mr. Martz was not out of luck, he had the ability to receive compensation under this agreement at whatever time the properties either were sold or permitted. Now,
or by January 1, you leave that out. So, in other words, if it's not sold or not permitted, then you have to pay by January 1. Let's stay with the contract instead of the allegations of the complaint. I mean, it's a...
Right. So I see that this is costing me dearly in time. So what happens is In this case, the plaintiffs, the appellee, was asked for discovery for what the value of the claim was. They identified an expert and full expert discovery, all of the issues that were related to how those appraisals were done. There is no appraisal, there was no evidence that was put forward on what the fair value of the property was. Fair value in this case would be as is, where is. In this case, both of these properties were unentitled and both of the properties were not subject to building permit. So what you had is farmland. It was farmland before this contract, it was farmland after. So the question then becomes,
But it was farmland after with the approvals. In other words, before it didn't have the approvals, and after it had the approvals to put on the development. And there was an appraisal the district court relied on to show the value with the approvals.
So the district court relied on there are two appraisers. One, the plaintiff's appraiser, was completely disregarded by the court, completely. That appraiser came up and disregarded. That appraiser came up with a number that was, bear with me, $3.9 million, $3.79 million. And Judge Quattlebaum, this goes to the questions on the issue of what the damages are. Their appraiser comes in and says the value of the condominium property was $3.7 million. The contract and the damages that were calculated would have had a priority of $1.89 million. So what that basically meant is whatever that number was, whatever number he came to for the entitled property, take off $1.89 million. And
well, see, taking off $9 million includes closing costs. The original value was 1.4 and some change. And you added closing costs to get it up to 1.89. But the court said, I'm looking at the differential in the values of the property. We're not computing damages. We're not computing damages. We're computing the fair value of the services based on the differential in property values.
So if the fair value determined by the plaintiff's expert was $3.79 million on 1/1/15, January 1st, 15, that's a value that he had as entitled and building permits issued, which means it was more valuable than it would have been as raw land before it was entitled. That $3.79 million under this contract would have been reduced by $1.89 million. Okay, so if you
I'm not okay with that, because you're using a $1.89 million figure, which is not justified by the record.
So if I guess part of this argument goes to the issue of whatever the expectation, because that is the argument.
Mr. Marcus, you're over your time, but I do have a question about, because you've raised this twice already. You said there was a quantum merit claim in the complaint. You said it twice, and I'm still trying to figure out exactly what the relevance of that is to this case. I mean, initially when I read these briefs, I thought you were suggesting that Mr. Marks was out of luck and he wasn't entitled to any compensation, but that can't be right. You're now saying, I think, that he may be entitled to compensation, but he actually has to wait until one of these two contingencies actually comes to the fore. So it would seem to me that he did work. He would be entitled to some compensation, right? So the question is how to calculate that. So what's your view as to what that amount should be?
The amount, we asked him in discovery for the value of his services. He had a quantum merit claim. It was contained in the original complaint. It sought compensation for the value of his services to make sure that he was in fact compensated.
But Mr. Marcus, that is a breach of contract theory of damages. The court did not give damages. There's a lot of difference between giving the fair, benefit. The court said, I'm not giving you the value of the approvals. What the court said, I'm giving you the benefit of how the defendants were benefited. And they were benefited by the contribution that the approvals made to the property. That's how they were benefited. That's not a damage theory. That's an unjust enrichment theory.
So, Judge, in order to make an unjust enrichment analysis, what has to happen is there has to be some kind of determination made of what is the value of the property before the benefit was conferred, and what is the value on the date that the unjust enrichment is to be measured. So you got to look at those two dates. We asked questions about what those dates were for January 1st, 2015. And their expert came up with a number of 3.79. Our expert came up with $2.45 million. And so if you took those numbers, what basically happened here is from going from an unjust enrichment, this was a lottery ticket, because by the time the court got done, the court awarded more money than what the claim was for the alleged breach of contract damage. So
okay. We'll continue this on your rebuttal. You've reserved time, and we've let you go on for a while.
And I've blown through my rebuttal.
Let's hear from Ms. Powell.
Thank you.
You're muted.
Minor detail. I'm sorry. May it please the court, Leslie Powell on behalf of the plaintiff appellate Byron Martz. We are obviously requesting that this court affirm the judgment of the district court on Mr. Martz's unjust enrichment claim. The court determined that the CSA and what we refer to as the ACSA are binding contract documents, and that if Martz obtained the change in land use, which he undisputedly did, that he was then entitled to compensation.
So Ms. Powell, I hate to get you off track from your argument from the get-go, but sure. You heard some of my questions. I think the best argument you have is C3, which and the language that says he gets paid at the earliest of, because I have a trouble understanding what purpose January 1st, 2015 and 4C3 has if there's
I'm sorry, Your Honor,
you cut out. Can you hear me, Judge Quattlebaum? Judge Quattlebaum?
I think he's disconnected.
Yeah, he's disconnected.
Jackie's going to have to call him.
Judge Niemeyer will pause argument, and I'll get a hold of Judge Quattlebaum. Thank you.
Okay.
Quattlebaum?
I can. Can y'all hear me now?
Yes, we can. And you were in the middle of asking Ms. Powell a question, and we heard almost none of it. So I don't know if you remember the question, but why don't you try again? Yeah, okay.
I do. And sorry about that. I was ranting and raving, and y'all were trying to stop me. So thank you for, or I apologize. But Hopefully this connection will remain good. So, counsel, what I'm trying, to me, the key question is, does this contract provide for compensation to your client by January 1st, 2015, if the property has neither been sold nor developed? And I think the best argument you have for that is that 4-3 makes January 1st, 2015 a date for which compensation is due. And that can happen before those other two events. So I think that helps you a great deal. But the part that I'm concerned about is that at the lead end of 4C, it talks about how you're compensated. And it has three words that may sound insignificant, but they are as described herein. And so then I'm like, what does that mean? And it means you get compensation, but only as described herein, or at least that's an argument. And the only types of compensation described herein are the formulas in 4A and 4B. So to me, I have one provision, the January 1st, 2015 date combined with the earliest of that suggests you get paid if you do this approval. But I got this language that as described herein, which arguably suggests you only get paid as the contract provides, and it doesn't provide any basis, any method of calculations there. And so actually I'm wondering why that isn't an ambiguity.
I think, Your Honor, well, the answer to that question is it's not ambiguous because there's a complete gap. And so maybe I'm not you're shaking your head, so I'm not sure I'm understanding.
Well, I don't mean to shake your head. I mean, I want, there's a gap only if the contract clearly says you get paid whether or not it's developed or sold. What I'm wondering whether the as described herein language at least creates an ambiguity that you don't get paid if it's not developed or sold. Or rather, another way of saying it is, sure, you get paid on January 15th or January 2015, but the way we calculate it is to go back to 4A or B, so your calculation is zero.
So, Your Honor, no, my answer to that question is, if you look at the language of 4C, it says, in the event Martz obtains the approvals for the proposed use as referenced in this agreement, compensation due from DDC to Martz as described herein, which are the three words you're talking about, shall be due and payable upon the earlier to occur one of the three following, and that compensation shall be due. So it doesn't mean zero. If it would, the contract could have easily said, Your Honor, if we decide to sit on this property, because that's what they did, if we decide to sit on this property, then you get nothing, even though you went to all this effort. And that is simply an illogical conclusion. And
so I think that's a good point. It could have said that, and then the defendant would be in good shape. Likewise, it could have said, you get paid on January 15th, no matter what. And you know, you may say it clearly says that. I think the as described herein, well, let me just ask you this. What does as described herein mean?
So, well, Your Honor, that actually would go to my conditional cross appeal, but that the court would have had to have used one of these two formula. But what it does say is that he shall be paid upon one of the following three events. And that is separate from the formula. And that's why the court found that unjust enrichment was appropriate, because it was missing essentially a material term with respect to item number 3, because it's unequivocal that it says you shall be paid either when you sell it, when you develop it, or on January.
I gather you claim, in other words, the very first sentence in paragraph 4 sets forth the critical language, which says, if he obtains the approvals, he shall be paid.
Correct.
And then the next two paragraphs say, and it says calculated as follows. And the next two paragraphs address how it's calculated.
Correct.
And they have a calculation for when it's sold and a calculation for when it's developed. But they have no calculation if neither occurs. And then the third, the C, as Judge Quattlebaum's noted, is when payment is. Right. And it says the earlier of those three events. But the calculation for if those events don't occur, the calculation is omitted, although the time is not. The time would be January 1.
That is correct.
Calculation, which should have followed the for A or B, there should have been a calculation if it's not sold or not permitted, then you calculate as follows. With the omission of that calculation, the district court applied the Maryland law, which says when you have such an omission, you do unjust enrichment. Right. But I gather that's where the governing language is actually the first sentence of 4, right?
Yes.
Unconditionally, it says upon approval, he's entitled to payment, compensation. And then there's two things they have to do, how much and when. And how much is addressed in the next two paragraphs and when is addressed in C.
That is correct, Your Honor.
Yeah. And the
I
court
just don't see why. I mean, Judge Niemeyer's questions are, I think, are fair. But I just, you know,
well,
the beginning language.
Yeah.
I'm sorry, Judge Niemeyer, go ahead.
Judge Quattlebaum, I was just assuming that's where the district court ruled. I'm not suggesting that's what we ought to do, but right. I think that's the basis for the district court's ruling. And if we understand that, then we can decide whether it's right or wrong. But I think this is not a well-drafted document. And I think you have to make heads and tails of paragraph 4 in its entirety. The function of everything. And I think there's a critical point is the very first sentence says, if he obtains the approvals, he gets compensation. So the intent of the parties is pretty clear and unambiguous. He's going to get paid if he got the approvals. Now the question is how much and when? And the district court said the how much is missing.
Paul, can I follow up on this? Clearly this contract was missing that critical piece that would calculate the payment due if neither one of the two things that were described in 3A and B occurred. So the question is how to remedy that, and the district court decided that it would go with an unjust enrichment calculation. But I suppose it could be equally as fair to say that, well, he's entitled to the time and value of his services on an hourly basis for the work that he put into it. So why is that not, and I think this goes back to your colleague's claim about quantum merit and the like. So how did we arrive at a calculation that was based on the fair market value of the property on X date, as opposed to just the time and value of his services on an hourly basis?
So the answer to that, Judge Diaz, is twofold. One, the plaintiff's entitled to select his remedies, his claims, and we did not pursue quantum merit. We pursued unjust enrichment, and the reason we pursued unjust enrichment was because there was a gap in the contract. There was a material term missing with respect to the calculation that would apply, the methodology that would apply if the property were sold on January 1, 2015. And so
that strikes me as a pretty arbitrary date. And is it fair to say that the other side, the opposing side, was unjustly enriched if neither one of the two things that they bargained for in the contract had actually occurred? That is the change of into what is it? Hold on a second. The sale of the nursing care parcel and the development of the property. Neither one of those things actually came to pass, right? So why? Go
Your
ahead.
Honor, they were in complete control of what would come to pass. And the evidence was unequivocal that they could have developed the domiciliary care parcel, and they could have sold it as well, and they could have also sold the commercial parcel. And there is absolutely no dispute with respect to that. Their own appraiser testified that yes, these properties could be sold, the 4.2 million for the domiciliary care parcel and the 1.1 for the commercial parcel could have been sold within 1 year. And the commercial parcel contract is in fact different than the domiciliary care parcel because that didn't require building permits to be issued, but that required was a finished lot value. And so, and the judge in fact noted in her opinion that there was ample evidence that this could have in fact been done. And so it's unfair to punish Mr. Martz for something that he had no control over, because at the time they executed the ACSA, he deeded his interest in this property at the same time as that contract to Day Development Company. At that time, Mr. Martz no longer had any control, and Mr. Martz had not been compensated for the commercial care parcel. And that contract provision was simply carried forward because that's why there was no stepped up deduction, if you will, in the ACSA. And so, no,
Let me
it's
go
not.
back to you. Let me go back to Judge question, the question of quantum merit versus unjust enrichment. I understand the difference. I gather quantum merit focuses on the value of the services he provided, and unjust enrichment measures the benefit that the other side got. You focus totally on the benefit. So if it costs him $5 to do it, a quantum merit might award him $5. But if the benefit yielded $100 to the defendants, then unjust enrichment would give him the get back the $100. That my question comes to the initial question that are you entitled to select either method? Because both of them were in play at one point, weren't they?
Well, they were in play, Your Honor, but I would suggest that in this case, what the bargain for deal here was, as indicated in the contracts, even though she applied unjust enrichment, was that Mr. Martz would in fact get the benefit of his bargain for the enhancement of value in the property, because that's what they agreed upon. The January 1 date did come and go. There's no question. And there's no question that he didn't get paid. But there's also no question, Your Honor, that Day Development Company didn't do anything to advance the ball when it could have. And in fact, it's uncontested that the principal of DDC, Mr. Day, told Mr. Martz, I'm not going to pay you. I'm going to take the property from you. And there was complete radio silence from the other side. I mean, that is...
Now, if the property had gone through one of the two contingencies discussed in the contract, that is either it was developed or sold, Mr. Martz would get half of the proceeds? Is that, do I understand
yes.
that? Yeah.
Yes, Your Honor.
All right, so that might be a reason for justifying the unjust enrichment, because he had an interest in the value of the properties.
Correct.
And if his services enhanced the value of the properties, that's a benefit that they obtained and the court awarded back.
Well, and that's absolutely right, Your Honor, because the recorded agreement, the third piece, the third agreement that these parties had relating to this whole project explicitly said that Martz had an equitable interest in the property and an equitable interest in the proceeds. And I think that makes it clear that this type of remedy was appropriate. And then just briefly, if you will.
Ms. Powell, I'm sorry, just to
Sure.
follow up on that. So your colleague on the other side suggested that, your client's remedy was really to wait, however long it took, apparently, according to them, for one of these two contingencies to actually materialize. And that's problematic, I think, because there's got to be some endpoint to this. But on the other hand, I suppose if they made an argument that, well, the market at this point is just terrible. It's just not conducive to selling these properties, and there's no point in developing a condominium because no one's going to rent them. It's better for us to wait until the market improves. And but your point is your argument that it doesn't matter. A contract is a contract, and we're entitled to be paid. Is that your?
Well,
argument?
actually, Your Honor, that is in fact the law. Just because somebody thinks he may have made a bad bargain doesn't mean that you get to walk away from your contractual obligations. If I could just finish my answer, Judge Niemeyer.
Yes.
Thank you. The contract itself allowed or took into account market fluctuations, because if, for example, the appraisal had come back, the non-litigation appraisal, if you will, if that appraisal had come back and said, well, yeah, it's only worth $2 million, then we'd be talking about a lot less money. And so that formula, or the analysis, if you will, taken by the judge, accounted for market forces. And so everybody would have just made less money, and a development company could have just sat upon it. And I know I'm out of time, so.
All right. Thank you, Ms. Powell. All
Thank
right, Mr. Marcus. Rebuttal. You want to unmute? Yeah.
Can the court hear me?
You're breaking up a little.
Yes, sir. If Your Honor, please, a couple of things need to be hashed out here. There is no doubt that the property under the rezoning domiciliary care to the parcel of 189 condominium units was not saleable. And there is no doubt that whatever it was in terms of the value that Mr. Martz brought to the property, all of the appraisals were predicated on a completely different concept. They wound up shifting from condominiums because they were not marketable in that market at that time. And the appraiser for the plaintiff had to use a completely different style and a different plan for the community because the condominiums were not saleable. Now, so when we say, okay, what is the value of the work that Mr. Martz did? Every one of the appraisals.
I don't think that's the issue. It's not the value. I thought we established it's the benefit that you obtained. In other words, as opposed to the value he contributed, he could have just made a single phone call and got those approvals. The measure in this case of the approvals is the benefit that you receive. So if you address the benefit, it'd be better.
The benefit, Judge, is the flip side of whatever the value is. So if the property didn't increase in value at all, let's just use that as a possible. If the property did not go up one dime as a result of the work that was done by Mr. Martz, there's no claim for unjust enrichment because
I think you're right. I think that's right. Yeah.
Okay. So in order for us to determine what is unjust enrichment, and by the way, unjust enrichment, that first word about unjust is an equitable concept that's applied to these damage claims, unjust. And so what wound up happening here is Mr. Martz secured a project for 189 condominium units in various buildings. The way the plan was submitted, and the court will see it, was there were 6 4- or 5-story buildings. Those buildings were not going to get built. They were not going to be sold. Everybody agrees, including their expert. And so what winds up happening when it came time to value what Mr. Martz contributed to this effort, if you were going to try to determine what that was, everyone determined that there was no market for that concept. What would have had to have happened was a completely different style. It's called 2/2s. All right, it's a variation on townhouses. Different concept, different engineering, different site plans, different expenses, and all the things that go along with changing this plan. So what winds up happening is when the values have to be assigned, or the determination on whatever it was, the measure of the unjust enrichment, we have to switch. We can't use what Mr. March brought to the table. Mr. March brought 189 condominium units, which were unsaleable and undevelopable. So when the issue of unjust enrichment is assigned to this set of facts, every dollar amount, including the 2013 assessment that was done for planning purposes, internal planning purposes, to compare with what the circumstances were in the market, to see what kind of products might be available, what kind of products might have public acceptance so that we have people actually buying them. They didn't use 189 condominiums. And when their expert went in, he valued 189 apartments. Now, the court, every member of the court recognizes the marked difference in development between 189 apartment units versus 189 condominium units. If you're going to try to value apartment units, that's a build and hold. That means that investment is not going to be an out sale. It's going to wind up being a property that is held for a long term or under some other financing structure, but it's certainly not going to be sold to the market. If it's a condominium unit, then the expectation is that the development will take place, there will be out sales of those, and at the end of the process, the seller winds up moving on to something else. The plan that Mr. March supposedly brought, the values that were assigned were not for that 189 condominium units. And so what winds up happening, we asked, okay, in order to do this, and back to your point, Judge Niemeyer, in order to do this measure, you got to figure out what was the value at the time that the property was obtained, and what was the added value that Mr. March brought to it.
Let me ask you, where did the district court get the 4.2 million to conclude that that was the value of the property enhanced by the approvals?
This is in 2013. The appraiser goes in. They're looking for possibilities on what kind of developments might be appropriate, what will meet the market, what can we do in order to have this project become a successful operation. So they come in and they use a model, and the model was 2/2s, because the 189 condominium units were not really viable. So he comes up with 2/2s, and I believe it was 132 units or something like that. But it would have required all new engineering. It would have required all new soft costs. It would have required a different site plan. And he uses that number and says, if we can make this work, and this is 2013, if we can make this work, this is what you can expect if you get a different kind of land use approval. Now, the court takes that, and there are qualifications all over that. It was done for planning purposes. It was not done for any other use. The expert, the appraiser, qualified it every which way. When it came time for the appraiser to put his name on the bottom line as to what it was that the value of the property was on January 1, 2015, his number was 2.45 because he was now using that same calculation of 2/2s. And when it came time for the plaintiff's expert to come in, he didn't use the value that Mr. March had brought, because Mr. March had 189 condominium units. And so what the value that they used came in at 2/2s, 3.79 million. So what winds up happening here for this unjust enrichment, unjust enrichment is exactly right. If he had gotten the contract value would have required 1.89 priority under these agreements. In other words, whatever that value was would have been reduced by 1.89. So equity being the critical.
So what your argument is, what was the value that the record showed as of January 1, 2015? Is that 3.79?
That was what their experts said.
I know, but your argument is that's the best they can claim for a value as of 2015.
Well, actually, that's the evidence they put on. The value of the property at 3.79 million was entitled. Okay, that meant that it had been approved and there was a plan for it. The property had not been approved, and that 3.79 million included the engineering, the plan submittal, and the approvals from the local authority in order to make that work. So if I said to you, Judge, that's the number they had, that 3.79 million was not really 3.79 million because the entitlements had a value independent of what the ground was worth. So from the standpoint, our man, Mr. McPherson, comes in and he says it's 2.45 million. He says that's the number, but it's not with 189 condominiums, not with the value that Mr. March theoretically brought to the table. So, and at no point in time in this whole case has there ever been a fair market value of the property as is, where is, in its condition as of the date of the value that's been assigned. So
yeah, but I think it would be wrong to measure particular plans. I think the question is, what is the value of the property with the approvals that had been obtained? In other words, whoever takes that clearly is going to have to put money into it. But there's a market value for land that is a zone for a particular usage. And the assessment in this case, regardless of carrying out how much cost it would develop, I mean, theoretically, the value of land is determined what would a buyer buy it for with that approval. So the approval's on there to put on, what was the approval for? 2/2s?
They never got 2/2s at that time. Didn't get 2/2s. Didn't pursue
What was the
it.
approval? What was the approval?
189 condominium units in multi-story buildings.
Okay.
That's what the approval was, which of course, nobody who testified in this case thought that that was a saleable product. Nobody. And the issue here was—
Well, it's not a question whether it's saleable, whether the property had any value as of January 1, 2015. And if it had value, what was the value with the approval?
Okay, I'm not going to wrestle with you about the approvals because that adds value because it didn't happen. But let's put it in that perspective. The fair market value of the property was typically the way an appraiser would have done his appraisal. That's what's done. As is, where is, willing buyer, willing seller. That's that fair market value. The appraiser was instructed to not follow that formula. And he was told to assume hypotheticals which were not consistent with what the reality of the situation was. There are standards. They're called USPAP standards, Uniform Standards of Appraisal Practice. And the standards are that you use fair market value. Maryland recognizes that in valuing real estate, you use as is, where is in its current state. If you sit there.
Okay, I think, in other words, basically, just to give what I think is a summary, is you're saying the court did not have sufficient evidence to measure the unjust enrichment.
And she admits it. I don't mean to disparage the judge.
No, but the court did recognize this is an equity matter, and it doesn't have to make firm calculations. This is unjust enrichment is an equitable award, and your argument is that she awarded too much.
Equity or not, okay? And if it was quantum merit,
so we're in equity. We're in equity.
All right, so let's suppose that this contract didn't have any other damage amount in it. Let's just suppose that you didn't have these alternatives. And March provided
I'm trying to get, you're not helping me because I thought I was trying to understand your argument, but I thought your argument was if we are awarding unjust enrichment, that there is no evidence or insufficient evidence to measure the value of the property as of January 1, 2015.
Yes, sir.
In order to, because that was the assumption the court did, the improvement of the property from the original value to the after the approvals, and the court concluded as a matter of equity that improvement was I don't remember the number, but
I think she winds up at like 1.9 million or something like that.
Yeah, right.
So
okay, I think we understand it.
Listen, I very much appreciate the court's willingness to let me drone on, and I've used my time. Pleasure to see all of you.
Judge Diaz or Quattlebaum, do you have any further?
I don't. Thank you.
I don't either. Thank you. Appreciate the arguments.
We've worn out all our time. I'm sorry we we held you over, but we appreciate your arguments. Our normal practice is to come down and shake your hands and greet you. The Fourth Circuit, this is a tradition that goes way back to 1930s, and we continue to do it. I know you both practice in the Maryland courts. I've never seen them do it, but it's a nice practice. And so we thank you for your arguments, and we'll adjourn court until this afternoon.
Thank you, sir.
Thank you.
The Honorable Court stands adjourned until tomorrow morning. God save the United States and this honorable court.